run into at least a potential conflict of interest. Maybe not a full-blown conflict of interest, particularly more for the plaintiff's lawyers that may be listening here today, but a potential conflict of interest. And whether it be a potential conflict of interest or a full-blown conflict of interest, we still have to resolve. We have to figure out what to do in a situation, which rules apply, and how to apply them. Now, you may think to yourself, why do seminars always talk about conflicts of interest? The rules are so simple. Do not represent A versus B. Don't be on two sides of the V, right? Well, that's part of conflicts of interest. But there's a lot more that goes into it. And there's a lot of situations that you may think to yourself, well, I never thought that could actually happen. Well, trust me, it can happen. And it's going to happen when you least expect it. How many of you have ever been in the throes of a litigation and all of a sudden opposing counsel pops up and you win? Or you're going to take the deposition of someone and then you realize, wait a second, that new witness, that person I'm getting ready to depose, is actually my client in another unrelated matter. A conflict of interest has just sprung up. There's also conflicts of interest that could arise in situations where two clients come to you and say, hello, I want you to represent both of us and do this agreement. We are trying to make a deal. We're trying to form a partnership. We're trying to create a business, and we want you to be the lawyer for the deal. Now, you may think to yourself, this is great. If I'm the only lawyer, I get all the fees, I get all the glory, I can help out two people. They look amicable. They say they've got everything worked out. What can go wrong? A conflict of interest can go wrong. You could also have conflicts of interest arise in estate planning situations. Say, for instance, you represent husband and wife. They have children. Their children have children. Now you're the lawyer for the family. Conflicts of interest arise all throughout that scenario because of what if the parents want to disown the children, but the children are also your client, and that you know they're relying on that money for their estate to give to their children. Do you have a conflict of interest? Do you not have a conflict of interest? Did you ever even consider that scenario? What if you throw in the aunts, uncles, and cousins into that scenario too? Estate planning can all have kinds of twists and turns. Also, to an estate planning, what if you represent a husband and wife? They have reciprocal identical wills where they're all going to leave the money. Whoever predeceases so-and-so goes to the next person. And then the disposition is, they've determined what's going to happen for the last surviving person. It's all going to go to their issue, legitimate and illegitimate. What if you find out that one of them has an illegitimate child, but the other spouse doesn't know about it? Can you disclose it? Can you not? Do you have a conflict of interest? Let alone the rules of confidentiality coming into play. So while the rules may seem deceptively simple, don't represent A versus B across, the line, there's so many scenarios that can pop up and so many instances where you're going to stop and think, oh my gosh, what do I do when there is this conflict of interest? So we always have to start with the basics on conflicts of interest. First, we have to know who is our client. Now, you may think, again, this is a very simple question. Who is the client? But I cannot tell you how many times I've sat across a table or sat at my desk with someone in the chair in front of me, and I've asked them, who's your client? And they look at me and they say, well, I talked to Joe over here, but, he owns X company, and then his wife owns B, but I do some work for them too. And I say, no, wait a second, who's your client? And they can't answer the question. And then I go a little deeper. Well, who's the client identified engagement letter? And they're like, engagement letter? I didn't do an engagement letter. It's an hourly fee. Who is the client? It always starts with that client's identification. We need to know who is the client in order to even start a conflict of interest scenario. Because if we don't know who the client is, we don't know who we owe the duties of loyalty to. We don't know who we owe the duties of confidentiality to. And we don't know who we owe the duties to avoid conflicts to, because we only have to clear conflicts for our actual client. And there are certain scenarios where someone may be paying the bills for someone else, but the payer is not our client, so we can still be adverse to them in other matters. So you have to know who is your client. Now, how do you really get that? You define it in the engagement letter. You set it forth at the beginning of the engagement. You specifically state, my client is X. If you're going to include all the subsidiaries and affiliates of a corporation as your clients as well, then you put that in the engagement letter. My client is XYZ Corporation plus all the subsidiaries and affiliates as identified herein attached via Exhibit A. And then you list them out. If you just say, for instance, subsidiaries and affiliates and don't actually list them out in the engagement letter or attach a copy of the list, it's very ambiguous. Companies and corporations change and gain and let go of subsidiaries all the time. So how are you going to track conflicts? How are you going to take all those entity names and put them in your database and know who you can and cannot be averse to and know who you have duties of loyalty to? You need to specifically identify the clients in your engagement letters by name, whether it be one client or 100 clients, they all need to be identified. Now, excuse me. Excuse me. Now, this can get kind of tricky too, especially when you have the joint representations or that affiliate subsidiary type of relationship, but we really need to identify the client. Now, if you say, well, I don't do engagement letter every time. Well, it is good practice and recommended to do them, even though the rules don't always require them. The rules require an engagement letter for contingency fee agreements here in Indiana, like most jurisdictions. And that's the only one that's really required by the rules. But do we always just do what is required, or should we do what is best practice? And best practice would tell us that with every new matter we open, whether it's an existing client or new client, we need a new engagement, or we need some confirmation regarding the scope and our client's identification. Whether that be a full formal engagement letter, an informal email, we need something. Because if you run into a conflict of interest and get sued for malpractice, I guarantee you the first question your malpractice insurer is going to ask you is, what does the engagement letter say? Who is your client? And hopefully you can answer that question for them and for any conflict scenario that could arise. Now, that is kind of where we define conflicts when we actually get the engagement, identifying them in the engagement letter. But what about those prospective clients? The ones that fall under Rule 1.18A, the ones that are, come for us for a consultation. We sit down and we give them 30 minutes, 20 minutes, an hour of free time normally, which some people cringe at that if there's a free consultation. They ask us or tell us about their case. We tell them, what we see, kind of a little bit about the law. And we also give them a little leeway into, do we want to take them on as a client? Now, if for some reason we don't want to take them on as a client, or they don't want to hire us and they go hire someone else, we still have that prospective attorney-client relationship that was formed. And that's governed by Rule 1.18. And this relationship also implicates conflict. Because once that relationship's formed, during that consultation, you may have or probably did gain confidential information, Rule 1.6. So you can't now normally go out and represent the other side of the matter that that potential client was discussing with you. There are cases where, say, someone comes to an attorney, talks to them, decides to go with someone else, and then the person that entity was suing or that person was suing then comes to that same attorney, talks to them about their side, and the lawyer's like, oh, yeah, I want to deal with that. So then they hire or they get hired by the defense when they'd already talked to you, potentially being the plaintiff's lawyer. That's a conflict of interest. So anyone that consults with us about the possibility of forming that attorney-client relationship is a prospective. This then attaches our duties of loyalty to them, our duties of confidentiality to them, and a duty to clear and assess conflicts. Now, the conflicts are really more going to be assessed on whether did we gain confidential information that now is going to be adverse to them or hurt them during the process. Plus the impropriety, just the appearance of you representing the other side after consulting with their adversary. It doesn't really look very good either, and that perception just says maybe something shady is going on. So we have to look at these things closely, especially when it comes to those prospective clients, and realize or try to figure out what knowledge did we gain is that information we gained would now be used adverse to that potential client if we take on the opposite side of the representation? And the answers to those are yes. Then under Rule 1.7b, we probably have a material limitation or direct conflict of interest that we need to resolve. And so we have to look at those prospective scenarios as well. So we have those situations that I was talking about first, where we have our actual client, meaning the one that, come through the engagement letter. We have our prospective clients, the ones that, come in and we don't fully engage them, but we still owe them those duties of loyalty, confidentiality, and clearance of conflict. And then we can also have what's called implied clients. Implied clients is a fun one. How many of you have ever been out and about talking to different people, and one of your friends or old high school buddies or college buddies come up to you and goes, "Hey, you're a lawyer, right? Let me ask you some advice." And they go into this long-winded scenario about this legal issue they're having, and then you give them legal advice. This could be that scenario we were just talking about. For a prospective client scenario, you don't have to be in an office, sitting at a desk, the other person in a chair, or at a table in an office. It can be standing at a party, engaging in that conversation, and giving legal advice directly related to a situation that they are asking you about. This could be a prospective client consultation, just in a different atmosphere. And if it is, or if the person that you're speaking with thinks it is, you just now have an implied client or a prospective client that you really didn't intend to make, but you did. And it's all about the perception of the person you're talking to and what they believe. And also, too, did you render legal advice? Were you directing at a specific type of scenario? Was it likely that person is going to rely on it? Those types of factors will be considered. But we really need to make sure that we have those different scenarios and that we have those things in there that we need. And in the textbook, it says page 4 of the textbook, that's kind of a little note for me. There's a textbook that I use that with these cases in there are 8 different situations that really imply this conflict of interest. And one of those situations is this, back and forth with, a person at a party or with someone when we're in those scenarios and in those situations. Some other ones can be too through an email conversation, through a Facebook message conversation, through a blog posting. These are all online resources too that we have to watch out for. Because just because we're behind a screen does not give us an anonymous sense of self. We actually have to, realize that anything you do online is just like we're in person. So if you can't see the person on the other side of that blog post, that tweet, that message that comes across on Facebook, it doesn't mean you're not having a prospective client consultation. You're just doing it now in a virtual era. So you really have to watch out for those situations. And sometimes that attorney-client line and who's the client can get blurred in those situations. Some other times when it can get blurred is employer-employee contact. For instance, say you're the attorney for an employer or a company, and an employee comes to you and asks you legal questions. They know you're the attorney for the company, so they just assume since they're an employee of the company, you're their attorney too. But you're not. If you go into rules 1.7 and 1.13, we know that for a corporation company or even a government entity, that our client is the person, the board, the top CEO, that's the chiefs, or the person who directs and operates the company. It's not the employee. And so in those conversations, what do you do to protect yourself? Kind of what do you do? I'm here. I'm getting asked this question by a friend at a party. You need to make it clear your relationship or your non-relationship. You could say to that person asking the question, that's a great legal question. Why don't you make an appointment and come in my office and we can discuss it? Then you have more control over the prospective client situation. You have more control over the different scenarios that could come up, and you can document and go through the normal process so there's no confusion on who's a prospective, implied, or actual client. On the blog posting and that, just don't answer them. Just refrain from posting. You can also, if you feel that urge to respond, put disclaimers on to try and protect yourself. Is it 100% guarantee? No, but it does help some. If you're in kind of the situation with the employer-employee type of relationship scenario, you need to verbally tell the employee, hey, I'm the attorney for the company, not for you specifically. And so you need to seek your own outside counsel. Just don't answer the situation. Respond with something that is communicative, that is respectful, but get yourself out of the situation. Some other situations that are right for implied relationships can be public speeches, talking in front of people and then asking you questions, say like seminars like that. Kind of you guys ask sometimes questions back. Sometimes I get, oh, my friend had this scenario. I'm like, do you really have a friend or is this about you? Those types of things can really have that. Do we have that attorney-client relationship implied being created? Most case law says when you give speeches, give seminars, no, just because the context it was given in is there for educational teaching purposes, not that attorney-client scenario that's envisioned or that should be, thought of pursuant to the rules. Advertising too, if you give too much legal advice through your different advertising ads, you need to watch what you say in those ads. Obviously, different jurisdictions have different requirements. Stick to the requirements and you should be okay. Auditioning other lawyers too, or auditioning lawyers as well to be part of a firm, asking questions. Also too, auditioning could be those prospective client relationships or when companies send out RFPs, requests for proposals. They could say, hey, tell us, who you represent, what you do, and you're giving legal advice based on the situation they know that you're bidding on. That's a prospective client relationship. Some people don't look at it that way because it's a paper back and forth. Again, not that one-on-one face-to-face. Pro bono services, e-lawyering, same thing. We can have those implied clients. Pro bono, you say, well, I was just doing them a favor. I just filed a motion or two. I just went to the hearing for it. That's still a client, actual implied, giving free legal advice, paid legal advice, still a client, still a prospective or actual client. You need to watch out for those. There's no exception for family friends either. So at those holiday parties coming up with your family, Aunt Joe or Aunt Jojo coming up to you and saying, hey, I hear you're a lawyer. What you doing? How's it going? I have a question for you. Prospective client relationship, tell Aunt Jojo to make an appointment, come to your office. She's probably not going to like that, but that's okay. You need to protect yourself when it comes to those ethics. Also, dealing with unrepresented persons on the other side of a matter, we need to make sure that they know that we do not represent them and that we cannot directly give them advice, but they need to consult their own attorney. You represent the other side, and that's how it needs to be set forth. And then two, consulting with other lawyers. Just, those parties too, where the ISBA and the State Bar Association or other places, you could go to those parties and lawyers ask, what are you working on? Hey, I have this case I'm working on. Can you give me some advice? What would you do? You've got to be careful in those situations. Those can all create these implied relationships or these implied situations now where you're conflicted out if that opposing side comes to you and wants you to represent it. So we always need to proceed with caution. We need to proceed with caution in the conversations we have with prospective clients, acquaintances, friends, colleagues, people we haven't seen. Tell them to seek legal advice. There is a case that is kind of being referenced through these slides too. It's a toxic case. It does talk about just giving legal advice in those, one-off casual scenarios. And especially in scenarios where someone comes out to you and asks you, hey, can you opine on this labor and employment matter? Well, you're an IP lawyer, but you're like, yeah, why not? I'm a lawyer. You gotta be careful. And even if it's a law student or someone else, Toxid says that can be considered legal advice. And it's not safe to do because it could be a violation of the rules. So even if it's on a subject matter you're not familiar with or on an area you're not familiar with, you need to really look at what you're talking about and just tell them to go seek the advice of a qualified lawyer. Humbling as that is, or go make an appointment at your office, you need to tell them to make an appointment and talk to a lawyer. But in any conflict situation, we have to learn to identify that client through these prospective client scenarios and also into our current client scenarios. current clients of conflicts of interest are governed under Rule 1.7A. 1.7 tells us that a lawyer's representation creates a conflict of interest if the representation of one client is directly adverse to another current client. Now let's take, for example, and let's boil this down. We represent Google. Google, we do real estate work for. Great, lucrative. Yahoo comes to us and says they want us to represent it, adverse to Google in an intellectual property IP matter. Google's a client. Some lawyers would look at this scenario and say, wait, they're unrelated areas as well. One's real estate, one IP, no issue. That's not what the rule says. The rule says we cannot represent one client adverse to another client. It doesn't say if, unless they're unrelated. It doesn't say that. And nowhere in the exceptions or their comments does it say that either. So even in this scenario where we represent Google in real estate and Yahoo comes to us to do an intellectual property matter adverse to Google, even though the matters are unrelated, we cannot take on the representation for Yahoo adverse to Google until we get informed consents confirmed in writing from both affected clients. So we would need to go back to Google and say, hey, Google, Yahoo's come to us, wants us to represent it in this unrelated IP matter. Do you consent to us representing Yahoo adverse to you in this intellectual property matter? Google says, yes, great. That's one side, consent coming two. We go to Yahoo on the other side. We say, hey, Yahoo, we're happy to help you with this matter adverse to Google for your IP work. However, just so you know, Google's a client in real estate matters, unrelated to what we're doing for you. We're going to continue representing Google in real estate matters, but in order to do that and to take on your representation, we need your consent. Google's already consented. Do you consent? Yeah. Yahoo says yes. Great. Two. Consents come in two. Both affected clients. Now, if either Yahoo or Google would have said no at any time, we're dead in the water. We cannot take on the new representation for Yahoo. We have to gracefully decline it. Yahoo has to go find another attorney to do the work adverse to Google. We cannot drop Google like a hot potato. Have that hot potato rule in there. Can't say, oh, we want to be Yahoo. Yahoo, that's a bit. No, we got to stick with our client. We can't just drop one to take on the other to try to avoid the conflict. Hot potato dropping one or the other does not cure conflict. What also doesn't cure this conflict is putting a screen in place between the attorneys doing the real estate work and the attorneys doing the IP work. A screen does not cure conflict. It's there maybe as a precaution just to make sure no confidence is past that line and to give the client a little comfort, but it doesn't cure the conflict. We still need the two consents, one from each affected client, to cure the conflict. The only thing that could cure a conflict is consent. So we need to make sure we get those consents. We cannot just rely on a screen, and we cannot drop one or the other like a hot. The other part of current conflicts that comes into play is 1.7A2, where we have a material limitation. A material limitation can arise in the absence of that direct adversity, like we just described. This can be a scenario where, say, for instance, we are doing some work for one client and we're advocating one position, taking a positional type of conflict, and then another client comes to us and wants us to take the opposite. That's a positional kind of material limitation conflict. It's not a direct conflict because the clients aren't, head to head adverse to each other in anything related or unrelated. It's just we're taking positions on both sides of an issue, and the firm can't really win here because that's going to affect the client over here. So we've got to, that's a material limitation we have to work out. And normally in those are not consentable. It depends on the scenario, but that type of one I was just describing probably wouldn't be consentable. Ones that could be consentable material limitations can be personal material limitations too. This can be things like, say, for instance, you want me to represent an advocacy group for animal rights. Well, say, for instance, I don't believe in animal rights. Not saying that's true, just giving an example. And so I come to you and say, I'm happy to take on the work. I think I can still zealously advocate for you. However, just disclosing that I'm a member of the opposite organization in my personal capacity. The client can say, okay, great, we don't want you to represent us, or okay, we'll waive the conflict. We know that you can put your personal aside and zealously advocate for us. Now, if they say, no, we don't want you to represent us, usually personal limitations and those conflicts are not imputed upon the rest of the attorneys in the firm. So you as an attorney that has that material limitation, that personal conflict that I was describing, can be set aside or screened off, and then someone else in the firm take it. Material limitation doesn't always come with imputation, like direct conflicts do. Direct conflicts are imputed to everyone in the same firm. The firm is treated as one. Material limitation, it's more on a case-by-case basis to see if imputation would be there. When we're looking at that material limitation, we look at, is there a significant risk that we cannot zealously defend or that we're going to pull our punches? That's what we want to look for. And if the answer to that question is yes, or the answer to that question is yes, someone would perceive we're doing that, then we need to either get consent or not take on the matter, or figure out if imputation comes into play and if someone else can take. That leads us into rule 1.9. 1.9 is former client. 1.9 former client, we do have to look at, it's a little different analysis. We can be adverse to former clients so long as the new work we're taking on adverse to a former client is not substantially related to the work we did for the former client. Substantially related comes in a broad definition, which we'll get to in the next slide. But if it is substantially related, then we have to get informed consents confirmed in writing. If it's not substantially related, then we have no conflict. Substantially related, we look at, can we uphold the former client's expectations of loyalty, confidences, duties of confidentiality, those types of things. If we believe that we would want to use something from the former client's confidential information now, and that it would maybe adversely affect that former client or breach those confidences, then it's substantially related. We really have to look at, are they same, dissimilar, same nucleus of facts, same issues? Are we going to use information we learned in the former client here in the new one adverse to that former client to their disadvantage? If any of those answers are yes, then it's substantially related and we need consents confirmed in writing. But former conflicts, we deal with substantially related standard and not just anything. So under 1.7, it's anything, even unrelated, we need consents. Rule 1.9, it has to be substantially related to what we did for the former client. So it's a huge difference between current and former client. And that is why a lot of times, if you have an internal ethics or conflict counsel, they really get on you about closing your matters, make it a former client, get it out of the system, make it a former client. It's because that conflict analysis, when it comes up, is so much more limited and so much an easier hurdle to overcome. That is just an easier analysis. And then you're not going to preclude out work as much. So getting those clients closed when they're done is important in that. The last of the conflicts rules that we're going to talk about, there's also rule 1.11 dealing with prosecutors and governmental entities, but we're not going to discuss it here today. The other one is rule 1.10 dealing with imputation. Lawyers are treated as one. Lawyers within a firm are treated as one, as I was saying earlier. So if I have a conflict, everyone in my firm has the same conflict citing, unless it's that personal material limitation type of conflict, then we'll look at it on a case-by-case basis. But if I hold clients, my partner down the hall has clients, my partner's clients are my clients are my partner's clients, my adversaries are his adversaries are my adversaries. We're treated as one within a firm, whether you're a law firm of 1, law firm of 2, law firm of 500, you're treated as one. Again, we have to watch that. Imputation rule 1.10 really comes into play with lateral attorneys moving firms. Because when a new attorney comes in with a book of business or treated as one in the old firm, they are bringing over that entire brain full of confidential information from the old firm to the new firm. So before that attorney comes through those doors, that new firm needs to assess conflicts of interest. They need to determine, has that attorney ever been adverse to any of the new firm's clients? If so, that attorney needs to leave them behind. You need to screen them off. So when they walk across that doorway, that knowledge is miraculously screened back. If they are bringing the client with them into the new firm and there's a conflict that you found, you need consent in place. when they walk in the door or simultaneously getting them as they walk through the door. So in any lateral move or lateral attorney process, there's usually an assessment of conflicts, an assessment of what it looks like, what's coming over, what's not coming over. And that is because they're really guarding against those conflicts of interest, because the punishment, or I guess the sanction for having that and moving into that new firm with conflicts, is disqualification. So the old firm that knows this new firm has a conflict can move to disqualify that whole firm from their current work and current client if they allow the conflicts to come over without resolving them. So if you are moving firms and the new firm sends you a questionnaire saying, list all your current clients and adversaries, don't be difficult. Under Rule 1.6, you can disclose the limited names for conflict identification and clearance of conflict. Now, you can't disclose everything in there further about the clients and adverse parties, but the names for the conflict purposes. That is there to protect the new firm, to protect you, and to make sure no one gets disqualified and we resolve conflict and don't hurt our clients. But in any conflict scenario, like I've been saying, we have to remember who is the client. Because as you can see through Rule 1.7, 1.9, and 1.10, if we don't know who the client is, we can't even start to assess conflict. The other conflict rules we did not talk about here today is 1.8 regarding our specific conflicts of interest. These are ones where we have determined that a lawyer normally shall not do a certain action because of the appearance of undue influence, the appearance of impropriety, or the fact that it's a risk to the public. Rule 1.8 is usually shall not standards of certain areas that we cannot do because of a conflict or because it is perceived as a huge conflict of interest. And so that is why we really didn't go over here today, because they're pretty straightforward and they're just being bang boom. You read through them, it says you shall not do this, you shall not do that. Self-explanatory. Rule 1.11 deals with governmental employees, governmental lawyers, either moving from governmental work to private practice or private practice to work, and what that looks like too for conflicts and clearing in that lateral process. So if you are one of those governmental attorneys or prosecutors or anything like that, you would want to go to Rule 1.11 to see what that looks like for your conflict clearance if you go from government to private practice. Another area that's fraught with conflicts of interest is joint representation. Joint representation is where we represent one or more parties in the same cause of action. Either on the defense side, on the plaintiff side, we have more than one person that we're representing. Now, the problem with joint representation is we have to make sure all of our joint clients' interests are aligned, meaning that they are not going to be adverse to each other and there's nothing going to spring up or they're not going to want to claim anything against another one of the joint clients. So we really have to take a look at the representation, take a little forethought to figure out, okay, what claims are going to be asserted, what is each of these person's best defenses, and are any of those defenses or claims adverse to another person I want to take on as my client? The answer is yes. Interests are not aligned. We can't do a joint rep. The answer is no. You can do a joint rep, but you still need to make disclosures, because at any time there could be something that's unforeseen arise to where now one of those joint clients wants to be adverse to another joint client. So in the engagement letter or in an informed consent letter to the joint clients at the beginning, you need to explain the material risk and limitation, the duties of loyalty, confidentiality, and how that's going to work within the joint representation. And you need to confirm all this in writing and have each of the joint clients sign it and confirm they understand it. They also have the right to seek outside independent counsel to decide whether they want to undergo the joint relationship or, joint representation with you at the firm. And they have the right to say no, and they can go find their own counsel. But you need to make those disclosures, you need to document it, you need to have them sign it. This not only helps them assess if they want to undergo that type of representation, but it also limits your risk of malpractice and your risk of, getting a disciplinary complaint filed against you. Because if for some reason, in the midst of that joint representation, a conflict does arise between all the joint clients, guess what? You are out. You cannot choose your favorite. You cannot choose play hot potato, drop two, keep one. You're out. because you cannot advocate adverse to any of the joint clients. So disclosing that risk, making sure that they understand that if they do have any claims against each other, that you will have to recuse yourself from representation of all of them is imperative. Now, you can, in some circumstances, in those written disclosures, say if a conflict does arise, we all agree that I can continue to represent one specific entity, even if adverse to the others. But everyone has to agree to that upfront, that be in those disclosures and waiver and signed by the parties acknowledging it. So you can set forth what's going to happen if a conflict does arise, if you want a specific scenario to play out, but you have to make sure it's specifically stated, everyone agrees to it and understands it, and putting it in with those identification of the risks and disadvantages as stuff moves forward. At any time, though, that a conflict does arise, we always have to ask, is it consentable? If it's not consentable, we're dead. If it is consentable, like we've been talking about for the whole seminar so far, get the consent confirmed or not. Disclose your risks and advantages, get all the clients to sign it, good to go. Keys to that informed consent, make sure you describe that they can have an independent counsel, make sure you inform them of the risks, the benefits, and then obviously make sure you get them to sign the letter as well. Now you may think, okay, I know how to resolve conflict, so I know what to do when a conflict arises, but how do I even catch it in the first place? How do I know that Joe down the hallway represents, 20 entities in this space? How do I know his client's names? Well, you have to have a conflict type of internal database, and that's going to look different depending on the firm you're in. If you're in a large firm, you probably have a big independent database, either through an outside third-party agency like Intap, Elite, Aderant, 3E, something where you have operators operating it. You send them the names you want them to run through the database. They run them through it, and they spout you out a report saying if anyone else in the firm represents them, if anyone in the firm is adverse to that entity, and then you start that assessment of conflicts. You start going into your rules, 1.7, 1.9, 1.10, whichever one is applicable, even 1.18. So prospective client, current client, former client, we start figuring out which rule applies. Now, if you're not in a large firm and have those third-party databases, it could be as easy as, hey, down the hall, be adverse to that. It could be an internal database. If you're a solo practitioner, hopefully you have a great memory. It is just depending on the nature, size of your firm of practice, it's going to look whatever that internal conflict system for your firm is as well. We do have a question coming in the comments regarding this section before we move on to confidentiality. So I will take that up this time. The question is, how does the material limitation requirements interact with Rule 6.4, serving in an organization involved in reform of law with adverse effects to client interest? It would depend. If you are serving in an organization that does have, I guess, effects on the clients you're going to be representing, or if your involvement in that organization would make you pull your punches, or you would be perceived as not being zealously advocating for your client, it's a perception. And it's not your perception, it's an outside perception. Then you would want to disclose your involvement in that organization, disclose whatever material limitation it is, and just get your client to consent to it. And that's the thing. When in doubt, seek either outside legal advice or ethics advice, or get the consent, because you don't want to be at the other end of a disqualification, a malpractice suit, or disciplinary commission. Fine. So you really have to look, how would this be perceived? Am I going to pull my punches? Do I think I am? Would the client think I am? And if those answers are yes, then you need to disclose the material limitation. Just say, you don't think you're going to, you think you can zealously advocate both and still be part of the organization, but you just want to let them know and get their consent in front. So you need to look at those things, but that is a great question, because our organizational involvement and what we're involved in outside of just our normal clients does come into play a lot of times as well. So the next area we're going to talk about is confidentiality. Confidentiality is huge. It's the hallmark of the legal profession. Rule 1.6 tells us that we shall not reveal client information unless the client gives informed consent or the disclosure is impliedly authorized by law, meaning if court orders you to. So the informed consent means we cannot talk about anything with the client, anything in that realm of confidentiality without the client's consent confirmed in writing. Confidentiality is broader than the attorney-client privilege. The attorney-client privilege are those communications directly between the attorney with the client present or the client on the other end of the communication, via email or whatever it be. That's that blue small circle. Confidentiality is everything else around. It can mean the witnesses, statements, the evidence, anything around attorney-client privilege is also confidential. As long as it pertains to the representation gathered in the representation or gathered during the course of the representation of the client, that's all that red circle. Rule 1.6 protects that red circle and the blue circle inside of it. And a lot of attorneys forget that. They forget that confidentiality is way broader than attorney-client privilege. And they also forget that there is no exception to Rule 1.6 for publicly available information. Meaning just because it's filed on a public docket, just because it's in a public record, does not give you a license to talk about it if you represent that entity whose information is publicly filed. Which means you cannot even disclose the name of your client or who you represent without your client's consent confirmed in writing. You cannot disclose a client win, a jury verdict win, without your client's consent confirmed in writing. This is so important because this is where lawyers fall down all the time because they forget that. They also fall down on this rule a lot around the holidays. You may ask why. When you go to a holiday party or catch up with family, friends, or colleagues, what's the first thing they ask? Hey, what you been working on? Who do you represent these days? What's the last thing you can answer? Hey, what you been working on? Who do you represent these days? Because Rule 1.6 comes into play with confidentiality. You cannot disclose a client's name, anything regarding your representation of them without their consent confirmed in writing. The exception to that is the hypothetical. The hypothetical is a broad generalization of a statement of what you're working on, where the receiver of the information cannot identify the particular detail, name, different things like that. The receiver would not be able to garner confidential information or know who it's about based on the hypothetical alone. Now, this is kind of easier to do with in person, but it's harder to do when you don't know your audience. Like, for instance, today there's about 30 of you out in the audience. So I could give a hypothetical, but I don't know if any of you are going to perceive who or what I'm talking about. So a lot of the hypotheticals I give in my seminars are so broad, or they're made up, like just, a figment of my wonderful imagination where I write law school questions for students, because I don't want to go into anything confidential of my past clients or of the current firm I'm working with. And so you've got to really think of those things. But publicly available information is not an exception to Rule 1.6. So to post about that win, to post about who you represent, to post about anything like that on social media or talk about it with anyone, you need the client's consent confirmed in writing. How do you do that? Send them a letter, get them to sign off, put it in an engagement letter. The specific instances, such as publicly available information you can use. Put something in somewhere, have the client sign it, know what they're signing, and then you're okay. But get that consent confirmed in writing. The only exceptions to confidentiality include that you can disclose, they may stand though, in the event of fraud or to prevent substantial harm. But you have to disclose if the client's using your services to commit a crime or to commit fraud on someone. Obviously, we do not want to be criminal with our clients. We want to represent them to get them out of jail, not be in jail with them. So always make sure you keep that distinction. The one thing to always remember too is confidentiality and attorney-client privilege is a privilege, and the key holder to that privilege is the client. That informed consent confirmed in writing, or that the client can waive it, or you could waive it inadvertently. So we really have to think about different things. We know we can't disclose confidential information to a third party, but think about these scenarios. You're talking about client stuff. Maybe you're on the phone with a colleague, so you're talking to the colleague, so you're fine on that conversation. But then you're talking in a public place. So now people around you can hear your at least side of the conversation. That's confidential. So talking about clients in public places, even if the person you're talking to is part of the firm, part of that confidence is still very risky, and you could lose that confidentiality because if a third person overhears it, perceives or picks up some of the confidential information, you've reached Rule 1.6. Same thing with jailhouse telephone calls. They're recorded, they're not private conversations. Inviting others to a meeting. So say if you're meeting with a client and they say, hey, my sister, brother, and so in town, can they just come in their office with me? The answer is no. They're third parties, they break confidentiality. The only way that they'd be able to come in is that they could assist in the communication or the defense of the client in some way. And it's a very tight standard, and it's not always met just because they're family members. So you need to really assess this conversation. Sharing conversations with others later too, that, hey, what you working on can also be losing that confidentiality and a breach of Rule 1.6. One of the examples to take a look at here, Benny Wilson is charged with possession of stolen merchandise. The day after discussing the case with his lawyer, Benny discusses it with a neighbor. As long as Benny does not say something to the neighbor like, here's what my lawyer told me, his communications are still privileged. The answer is no. He's breaking it. He's telling the person, he's the key holder, he's the client. And the fact that he's telling the neighbor, that neighbor can now be called to testify against him or to testify to the substance of that conversation. So you need to also advise and educate your clients that they're the key holder. And if they inadvertently or intentionally tell someone else what they discussed with you, then the confidences are waived and that person can be called to testify. And they may be like, well, it's my mom, it's a sibling, it's a best friend. It doesn't matter. Keep it to yourself. If they want to talk about the case, have them come in and talk to you as the lawyer. Keep it confidential in those areas. Again, that attorney-client privilege is the smaller inner blue circle. It is directly communication between the attorney and the client, not anything wider than that. So forming that attorney-client relationship, obviously, it can be done through express agreement. Those implied relationships we've already talked about, the prospective client scenario, or just anything that can come up in those instances. So we really have to watch out for those areas and make sure know what we're doing. For an attorney-client relationship to be created, this is kind of those things that I was talking about earlier when we were talking about prospective clients, forming it and then having to assess the conflict. It's when someone comes to you where legal advice is sought from you as a professional attorney or advisor, and the communications are related to that purpose of giving legal advice, they're made in confidence by the client or to and from the attorney and client, and they're thought that they're going to be protected and confidential, and they have not been lived. So it kind of meets all those prospective client scenarios. Confidentiality attaches when we're talking about prospective clients who are in conflicts of interest. And once it attaches, it attaches. But we have to remember the client has the right to waive the privilege. The client holds the key to that privilege and can waive it, cannot waive it, intentionally waive it, impliedly waive it, but they have the right. So we need to educate them on why it's not a good thing to waive it. And those scenarios of the third party being present, talking on the phone, talking places, telling your neighbor, your mom, your friend, your sister, we need to advise our clients regarding those scenarios so that they don't hurt their own case. They can be their own worst enemy. So we need to make sure it's there. Again, these are just for kind of your benefit of the materials too. General rule, allowing a third party to be present during an attorney-client conversation waives the privilege unless the person is there to assist or aid in the cause. That is the one exception I was talking about earlier. Person will further the client's legal representation and it's essential, necessarily, and highly useful to be there. So just because sister, brother, Uncle Joe is in town doesn't make them essential. Essential means that in order to effectuate the communications between you and the client, you need that person present. You need them there to help. You need them there to do those things. Make sure your privileges remain intact. Know the precise role of the third party if they come in. Make sure you can meet the standard we just saw on the screen to get that exception in there. Otherwise, you're going to be in trouble. Let's do a couple examples here before we move on to our next topic. Soon after her arrest, Heidi speaks to her mother in jail. Heidi's case goes to trial, and the prosecutor calls Heidi's mother as a witness and asks her to reveal what Heidi said. Heidi's mother would probably have to answer because one, jailhouse conversations, if it's over the phone in the jail, are not protected. But again, Heidi's mother is not essential to the conversation, essential to the assistance of it, or we don't know we don't have enough facts here. So most states have also held that there is no mother-daughter or parent-child privilege in and of itself. So we really have to go into that exception of making them essential necessary, which we probably won't reach in this example. Another example, parents of witness who face criminal charges sat in on conversations with the lawyer and provided advice and guidance to their minor child son. The parents hired and paid for the lawyer. Now we all know just because they're paying doesn't make them the client. Just because they're paying doesn't make them the client. I'll say that again if you don't know that. This is to defeat the privilege. It depends on the scenario. Again, are the parents there and essential to the communication? Are they essential because the child's minor? We're getting a little closer to maybe having them be that essential exception. But again, there's no parent-child exception in and of itself. We have to meet that exception of having them essential. Defendant charged with second-degree murder. During a prior divorce case, the defendant brought his daughter to a meeting with the family law attorney. Could the family law attorney be called to testify at the murder trial on the substance of the communications when the daughter was present? Was the daughter essential? Those are questions you're going to have to answer. Now, they probably wouldn't call the lawyer. They would probably call the daughter to testify. Normally, again, there's no parent, client, and we would have to meet that essential exception. So you kind of get the gist of these examples. We really need that person to be essential. Here's one where we get a little closer to, we have an elderly mother, traumatic event from litigation, daughter has to drive her to and from, puts her at ease for communication, jogs the memory, age not. Now we're getting into essential. So we've got to look at the different fact scenario. Moving on to our next topic, you realize that you made a mistake in handling a legal matter. What do you do? First, you don't try to cover it up. Second, if you have an internal ethics counsel, you reach out to them. You have a general counsel, reach out to them. If you don't, you have a law partner, reach out to law partners, because having that outside independent eyes on it is great. Because when you're trying to fix your own mistakes, we have kind of a bias and an emotional response. We need to take that emotion out of it and make the business decision. So if you do make a mistake, do not lie, do not cover it up, do not try to hide it. Bad news does not get better over time. You need to talk with the client, you need to communicate what happened, and you need to tell the client how you are going to fix it. So you need to do this in a prompt, efficient manner and consult the necessary internal personnel and own up to the mistake. Now that it looks different depending on the size of firm you're at. If you're at a smaller firm, that could be a very informal process. If you're at a larger firm, it could be a very formal process. It can also be a scary process. If I could see all your faces and I ask you how many of you like to admit you're wrong, I guarantee you maybe one, maybe zero hands would come up. I mean, just think about it. How many of us like to admit we're wrong? How many of us like to admit we made a mistake? Not many lawyers do. Not many people in general like to admit those things. So when we do make this mistake, when we have a conflict that we didn't clear, when we breached our confidentiality, when we breached another ethical rule, we need to first recognize it, not try to hide it, not think it'll just go away with the passage of time. We need to report it internally with whatever procedure is there internally within your firm. Consult the right individuals, management committee, general counsel, ethics counsel, whoever you need to report to. You need to consult with them how you're going to handle it, especially if it affects the client. Then you need to make a communication with the client. Rule 1.4 of the rules of professional conduct require that communication with the client. We have to advise the client of the different material things that arise in our case, and a mistake by us is a material thing that arises in the case. Now, it's not going to be an easy conversation with the client. It's not going to be a fun conversation with the client, but it is a conversation that needs to happen under Rule 1.4. So we need to make that. So you realize you made a mistake in handling a legal matter. What do? Report internally, figure out a plan, communicate out to the client. Hopefully the client doesn't fire you. Hopefully you can fix the mistake. You also may need to in there, and this would be something to work with your firm too. You may need to advise your malpractice carrier. You need to look at your malpractice insurance and see if it requires reporting of potential claims that could arise. And if it does require reporting of potential claims, then that's something that could be a potential claim if you made a mistake. For instance, say you missed a deadline, say that you calendared it wrong. You're like, oh my goodness, I calendared it wrong. Now you're going to try to fix it, get it on file immediately, see if the court accepts it. But you still need to report it internally because you may also have that obligation there with your malpractice carrier to report that potential claim, because it is a potential claim. It's malpractice to miss a deadline. It can also be a disciplinary complaint, and your malpractice carrier will cover hopefully the attorney for the disciplinary or the malpractice lawsuit, depending on the insurance you have. So you need to take those steps. You need to remember your obligation. And bad news does not get better with time. How many of you like it when your spouse, significant other, friends keep bad news from you because they think they're protecting you? But then you're even more mad when you find out about it because they waited so long to tell you. Now take that same mindset and put it reverse into the client. The client's the one that now is going to be so mad because their lawyer forgot to tell them or decided to intentionally withhold the bad news because they didn't think they could handle it. Bad news does not get better with time. We need to make that communication. We're obligated to under Rule 1.4 of the Rules of Professional Conduct, and we need to make it in a prompt, efficient manner. The next topic, or the last topic here before you get your next speaker of the day, so this will be our last topic, taking us into the last 45 minutes here, is regarding what do you do when you suspect a data breach? And I always say when you suspect a data breach or someone coming at you, you just need to take cover. It's kind of like in the movies when they say, everyone take cover, something's coming, and you duck your head, you put on the helmet, you get ready for the attack, you brace yourself for it. And the thing with data breaches is we're bracing every day. They're coming at us 24 hours a day, 7 days a week. They're coming in through our phones. They're coming in through our computer. They're coming in through cloud servers, different areas. I mean, there are Trojans, there are viruses, there are worms, there are spywares, there's bugs, there's rootkits. Oh my, there's all kinds of stuff out there. And we have to, as lawyers, stay competent in all these areas because we have a duty to protect our clients' confidential data and information. And in order to protect our clients' confidential data and information, we have to stay competent under Rule 1.1 on all technology and things in order to effectively let us do our job, including protecting data. So when I say data breach and everyone take cover, I mean everyone take cover. Because it is coming for us, right? Coming from us, coming from up, coming from down, it's coming from all over. And so we need to take cover. And it was actually Robert Mueller of the FBI director, who was FBI director in 2012, was quoted as saying, I am convinced that there are only two types of hackers, those who have been hacked and those who will be. And even now, those two groups are converging into one category. Companies that have been hacked and will be hacked again. It is coming for us. There are so many instances that we hear about where they're coming in through our phones, through our emails, through those phishing scandals, through different areas. And we do need to learn how to protect ourselves and to protect our client data and their information on a daily basis. Now, if you are at a big law firm, you probably have an internal IT department that helps in this area and helps you protect client confidential information. If you're at a smaller or mid-sized firm, you may not have those resources and capabilities, but you still are going to be held to the standard to reasonably protect your client data and information. And you may think to yourself, well, why would anyone want it? We're just lawyers. We don't have, all this stuff like big companies or I have a measly 30 clients at a time. But you got to remember what kind of information we store. We store highly sensitive information about our clients all the time. Their social security numbers, their banking information, their credit card information, their birth, their HIPAA information. Anything and everything about a client that is right for a cyber criminal or a criminal to steal their identity is information we have. And so that is why they like to get into law firm computers to get that to steal client identity. Another reason you could be hacked too is we also contain client confidence and secrets. So say, for instance, you're litigating a highly public case, something that's made the news, media, made attention, and everyone wants to know what information you as a lawyer know that you can't tell the general public, or the general public doesn't know. Because we all know it's confidential. We can't tell anything what we learn unless the client gives us permission or impliedly authorized by law. So we have secrets. We have where the body is buried secrets. We could have, did this person actually do it secrets in our database? Because we can't disclose that information unless we meet one of the exceptions, Rule 1.6b. So sometimes public sleuths, people who are just nosy, you may not want to steal identities, but they want the information. They want the juice. They want you to spill the tea when we can't spill the tea because we're lawyers. They want the information we have. And we have to protect. We have to make reasonable efforts to protect. And you may think where the biggest security threats coming from, they're coming from everywhere. They're coming from ransomware attacks, which is our phishing and social engineering. They're coming from social media infiltrations. They're coming from misdirected emails, meaning to send out client confidential information inadvertently and now opened up a whole can of worms. They're coming from lost or stolen portable devices. How many of you have ever lost your cell phone or your computer or had it stolen out of your car or someplace else you were? That has client confidential information on it. They're coming from HIPAA violations. They're coming from improper disposal, shredding versus throwing it in the dumpster out back. Throwing it and letting the wind take the leaflets throughout the city instead of burning it. Or trying to burn it with a fire in the catch, and these little things flutter with all your client social security information. These are all areas where common threats are coming from, and these are all areas where we have to take reasonable precautions to make sure our client sensitive information is protected at all times. So what do we do? That's the question. What do we do when? What do we do when we have one of these attacks? And we are going to get to that answer. Some of how these client information actually look, it comes in forms of client filed information, it comes in financial forms, as we already talked about. The one thing we didn't talk about yet is that us as law firms that only hold client confidential information, we also hold employee confidential information. So the employers, your non-attorney assistants and employees, you also hold their social security numbers, banking account information for direct deposit, maybe credit card, maybe different things, addresses, phone numbers. That's all again right for identity theft, right for harassment and loan in different areas. So we want to make sure we're not only protecting the client stuff, but we're also protecting our employees because managing a law firm is part of practicing law. So we can violate the rules for practicing law if we mismanage our law firm. We really don't protect against this client confidential information like we need to. And the problem with data breaches is these are not attackers where we can go up to them and confront them face to face. Like we can't say to them, show your face, come out, put up your fist. Let's take this outside and duke it out. That's not what this is. Cyber crimes and the security and data breaches come from invisible people. Literally, probably working late at night while we're sleeping, trying to infiltrate through our, computers. Our computers may be off, they may be idle, we may be getting emails to our phones. They're trying to get in, and they're coming from all of those areas, like that first picture when we started this section. And they're trying to get you. They can be called hacktivists, they can be called criminals, they can be called insiders, nation states, terrorists, militants, military. It's an all-out war. And it's a war on the internet. It's a war through the cyber world that is so confusing and interrelated. It's a war where we don't know if we're facing someone over in another country or we're facing someone here at home in the United States. It's a war to keep our clients and employee information confidential. And who's going to win this war? Hopefully, we as the attorneys are going to win this war. And how do we win this war? I'm going to give you a few tips and ideas how to win it in just a few minutes. But we have to really first look at our ethical duties. We have a duty to make sure and reasonably protect our client confidences and that client information, as well as our employee information. So ABA Rule 1.1 tells us we have to stay confident in these areas. And again, if I ask you, how many of you out there are computer nerds, computer geeks, love this cyber world, know everything about the internet, know how to get into the black market, know how to back code and front code, or I don't even know if those are terms, but know how to code stuff to get in anywhere. And I guarantee you, out of the 30 some here in attendance today, not even half of you would probably raise your hand. I wouldn't even raise my hand. I know enough information to protect my clients and protect information, but I don't know all the coding infrastructure and, even the ins and outs like crypto and how to trade it and what to do and where it goes and what it looks like. That's all details too, but we have to have enough knowledge and we have to gain the minimum requisite knowledge to stay abreast in the changes of law. This includes technology. It includes the benefits and risks associated with relevant technology. It's right there, Rule 1.1, Common 8 on the screen in front of you. To maintain the requisite knowledge and skill, a lawyer should keep abreast of the changes in the law and its practice, including the benefits and risks associated with relevant technology. Technology means cyber stuff. Technology means social media. Technology means, if you want to get down to the nitty gritty, TikTok, Twitter, which is now called X. Maybe you knew that. LinkedIn, Instagram, trying to think all the ones without dating myself. MySpace, now I'm dating myself. Different areas of different platforms. We have to stay competent in it. And it's not just for cybersecurity reasons. It's also so we don't breach confidentiality. And it's also so that we know what's discoverable and what's not, because now different social media postings of our clients and platforms can be obtained through discovery. And so it can hurt our client and it can help our client. But if we don't know how those different platforms and stuff operate, then how are we going to be able to really help our clients develop the advocate? So staying up to date on this relevant technology is not just for cybersecurity reasons, the practice reason, the client management, the data management, and just understanding how those things interplay with each other. And then again, like I said, we cannot breach Rule 1.6. We've got that big red circle we've got to protect. And we've got that little blue circle inside of it of our attorney-client privilege. We have to protect it all. So we need to make sure we take those reasonable efforts to maintain our client confidences, to make sure we don't have any confidential breaches or client breaches through just cybersecurity. So if you take all this together that I've talked about here in the last few minutes down to one rule, if you wanted one rule to take about this, we have a duty to act competently to preserve and safeguard confidential client information against the unauthorized disclosure by the lawyer or persons under his or her supervision. This can be seen from Comment 8. The unauthorized access is not a violation if the lawyers make reasonable efforts to maintain the data. Now you may think, okay, well, I have a McAfee or McAfee, if that was tough, or like the Trojan detector on my computer. So I'm making reasonable efforts, right? I'm doing what's reasonably necessary. Well, reasonable efforts is a broad, undefined standard, just like a lot of stuff in the law. So what could be reasonable efforts for a small firm may not be reasonable efforts for a large firm. And what's reasonable efforts for a large firm may not be reasonable efforts for a medium-sized firm, or even by practice area. What's good for estate planning may not be good for IP, may not be good for litigation. So reasonable efforts can look different, law firm to law firm, practice group to practice group, and what attorneys and firms need to put forth in order to maintain that security in order to maintain the confidentiality that they need and what that's going to look like. So reasonable efforts to prevent unauthorized disclosure, not the one size fits all. It's a multi-factor analysis. Some of the factors a court will look at include what information is being kept, how sensitive it is, the likelihood of disclosure without additional safeguards, the cost, meaning a program that costs $500,000 may be great for a multinational law firm, but not great for a 20-person law firm. So they look at those two, the cost, and then in relation to the size or the subject matter area. Difficulty with implementation, meaning how difficult is it going to be employed through the firm, to keep it, to maintain it, to regulate it. Those things are considered too. Adverse effects of safeguards vis-a-vis the lawyer's ability to represent clients, meaning is all the safeguards going to prohibit sales representation, or is it going to help them, or not touch it or affect it at all? So these are just factors that should be considered when you're deciding what to do for your cybersecurity, what platforms you should purchase, what things you should do to protect your firm or lawyers in it and your client. These are the factors you need to look at, need to analyze, and really need to figure out what you need to do for those things. There are a couple of formal opinions one formal opinion, that I do want to make reference to. It's not included in your materials here today, but you can actually just put this, cut and paste it into Google, and it will pull up this. It's on guidance on email encryption, because another way we can have security breaches is through emails. And so encrypting confidential information through emails is vitally important too. Because think about how many times you send HIPAA information, or you send a document with your client's confidence in it from email to email, outside to inside the firm, inside the firm, inside the firm, different areas. And so how should we encrypt our emails? When should we encrypt our emails? And what does that look like? And it was ABA Formal Opinion 477R from May of 2017, when it was revised, gave us some guidance on what that should look like. And the guidance is, depending on the size and nature and those factor analysis, we should encrypt emails, and it's easy to encrypt. It's a plugin or an add-on to usually most Microsoft platforms, where you can make it password protected, that only the recipient can open an attachment, or both, or there's some encryption that occurs to where the person has to have a code or something to continue, which is great when it comes to making sure we protect our client information and protect their data. ABA Formal Opinion 2477R also went through what guidance for reasonable efforts, what they could look like. And it's going through, again, that factor analysis test, understanding the nature of the threat, understanding, our obligations to keep client confidential information confidential under 1.6, understanding the use of electronic security measures, why they're helpful, why they're not, and what's best for our organization. Communication with our clients can help too, telling them these are the safeguards we have in place, this is what we're employing, and leave it up to the client if they want to take the risk associated with those platforms. If you're sending emails or sending stuff with client confidential information attached, label it confidential. Label stuff internally being saved if it has that highly sensitive information, so that's readily identifiable, and so that someone just doesn't grab it and inadvertently send it out to where it shouldn't go or not encrypted. You also need to make sure that you train lawyers and non-lawyers on proper protocols and procedures when it comes to cybersecurity and maintaining confidences and fighting against these cyber attacks that we're seeing. This can be obligation of us as lawyers through rules 5.5, 5.3, where we have to supervise and train subordinate lawyers and also non-trained type of this. We also need to educate our third-party vendors that we use on security and the rules of professional conduct, because they need to know too what standards we have to uphold, because they have to uphold the same one. And if we're hiring them, we need to make sure that they have security protocols in place to protect their client information when we send it over to them for them to do their jobs. And also too, they understand that it's vital that they actually utilize different programs and utilize security as well. So if you are worried about your cybersecurity or what to look or for those reasonable efforts, really take a look at the ABA Formal Opinion 477R, which was revised in 2017. Now, since then, since 2017, a lot of stuff has happened for cybersecurity. It's gone really haywire. We've had a pandemic, we've had lots of stuff happen from 17 to 2023 right now. And so even that, when it was revised in 2017, taking that as a bounce off point and then doing your own outside research, reading additional ABA articles, reading articles specific to your local jurisdiction. Those can help you figure out what reasonable efforts you need to take and explore and the factor analysis. And communicating what you're doing, communicating it in your engagement letter, communicating with clients, making sure they understand how you're protecting their information is also important too. We have that duty to communicate, we have that duty to let them know what we're doing, and that includes also with our cybersecurity and how we are protecting Rule 1.6 information. So make sure you communicate it to your clients as well. So what do you do when a cyber attack happens? That's the question. First, you have a duty to disclose. You have a duty to internally report it up if you have a policy. If you have a general counsel, contact the general counsel immediately. If you have an ethics attorney or a corporate compliance officer you need to contact, then contact them immediately. Not only you have the duty to disclose internally potentially based on your company's policies and firm policies, you also have that duty to communicate with the client regarding the breach of cybersecurity. If it is a corporate client, you need to look at their outside counsel guidelines. Outside counsel guidelines from corporate clients sometimes have provisions in them that say, if a breach does occur, this is the procedure you need to follow. This is when you need to notify me, this is the information I need to know. And so you need to comply with those guidelines. If you do not have guidelines from a client, you need to go under Rule 1.4, communicate to them, have a plan in place, do not lie to them. Bad news does not get better with time. Tell them what you're going to do, tell them the risk associated with what happened, and tell them how you're going to fix it. Now, in the earlier communications with the client, like that engagement letter, you can let them know the different types of platforms and stuff you use so that they know the risk associated up front, so that if a breach does occur, that they're not going to be blindsided by it, because you disclosed up front, the security measures have in place, stuff happens, and then they're not going to be blindsided. They're not going to be happy, but at least they're not going to be blindsided. So you can always take that initial step in making sure you inform them in the engagement letter of what security features you have in place, so that if a breach does occur, they're not blindsided by it. Once a breach does occur too, you have an obligation to monitor the breach, and the obligation to fix it as well. So just because maybe a worm or someone's now infiltrating your files, you have a duty to now seal those holes when they come in, the virtual holes, and try to find how did they get into your emails, get firewall, where did they come from? Seal those off, re-up your data security, figure out how to protect against them in the future, and then monitor. Don't just say, okay, well, we got them out, we're done. No, do what I call an after action review. You go back and say, how did this happen? Okay, we have these things in place, they still got it. How did they get in? What holes were there? Where did they get in? Now let's fix those holes. Okay, we fixed them. Now can they get in again? If so, using the same type of stuff, we need to amp our security up. So you have to take that after action review to figure out what happened, where it happened, and how do we prevent it in the future. And this is something too you can communicate to your clients of how you're fixing things and what you're doing to amp up that, so this occurrence doesn't happen over and over and over again with their client confidential information. You want to keep it on the lockdown. You want to keep it, as confidential as possible. Taking that into, let's look at some examples here. These are some examples of some of the biggest areas where we see security and data breaches and cyber attacks coming in. So we'll go through about 5 of these together, and then we'll talk about an incident response plan and stuff you can do internally in your firm regarding policies and procedures before we close out at least my session here for today. But I know you have a great another seminar speaker coming up after me. So The first thing I want to talk about is phishing and social engineering. This is one of the biggest areas where we see cyber attacks and security data breaches. So in this example, John works for a large law firm. One afternoon, he notices an email from his information system, which IS or IT, you can call it technology systems or internal technology departments. The message states that his email has been compromised and instructs him to immediately reset his username and password information by clicking on the attached link, which John promptly does. The next day, the managing partner of the firm calls John the managing partner of the firm calls, stating that the organization has experienced a significant data breach of over 3,000 client files. And this data breach has been traced back to John's terminal. The managing partner asked John, what did you do yesterday? Did you click on anything recently? Was there anything odd pop up on your computer? John thinks back and he's like, oh, I got that email to reset my password and I clicked on it. So what did John do wrong? What is the proper ethical response? And now what duties are triggered by John's actions and the duties of the firm and the duties of John? So let's start with the first one. What did John do wrong? Well, John clicked on an unknown link. A lot of times, knowing how to identify a phishing email is half the battle. You look through things like misspelling, odd spacing. You look closely at the email address, it's going to be off a few characters or look really weird and funky in certain ways. Some other things too, John may have thought to himself, oh, I have to click on a link to reset my password. That's not normal. Normally I hit Control Alt Delete. You have a task menu pull up, it says reset password or change password. He could have thought to himself that critical thinking, that's how it's normally done. So why is it different? Instead of just relying on the information in the email. So what he did wrong was he didn't have his radar up. He didn't suspect. And we should always have a radar up, especially in today's day and age when we get weird looking emails that just feel a little bit off. We're like, well, this isn't normal procedure. Then we need to start asking questions, ask why. So John could have, instead of clicking on, if they had an internal IS department, which the scenario says he does, send it to them and said, is this safe for me to open? Now, if the internal IS department says no, then he knows it's phishing, spam, don't click on it. If they say, yes, this is from us, and please verify it's safe, then we wouldn't have had 3,000 files. He could have also just deleted it. You always get at least 10 of those notices and see if another one comes through and talk to IS later on. But he did click on it. So now we're left with that. So the proper ethical response, obviously, he needs to admit what he clicked on so that the firm can assess how the breach came in, try to guard against that spam email, alert other employees in the firm not to click on a phishing email, and they need to start filling the holes and figuring out which data has been breached and which data has not been breached. In addition to that, they need to have a response plan to how they're going to communicate the breach to the affected client. So they need to identify those 3,000 client files, who's affected, what information is affected, and then formulate communications with 1.4 out to those clients to alert them of the data breach, how they're handling it, and what they're going to do moving forward to make sure it doesn't happen again. And that's it. As for John himself, he needs to be upright and honest with his firm. If he has direct clients associated, he needs to help with those communications, tender the response formulated by the firm as a whole, stay calm, and know it's going to be okay. Hopefully it can be recovered. Hopefully there's not any huge problems with the data breach link, but he just needs to be honest and work with his firm's management, work with IT, and know that he needs to keep being honest every step of the way, even though it's hard, discomforting, but that is what we need to do as lawyers in those circumstances. The next scenario we're going to go through, Betty is a paralegal at Mickey Mouse LLP. She regularly handles client medical records and sensitive data. Occasionally, Betty must dispose of printed health information. She understands that information is sensitive and must dispose of it securely. But the nearest said receptacle is in practice is down the hallway. So it's a little walk for Betty. Betty's a little lazy. She doesn't want to walk down the hallway. Betty keeps a shred pile box under her desk, which is an open box. She throws papers in there. She needs to shred. But she only has to walk down that hallway once a week, and she doesn't want to get her steps in. She wants to go once a week. Betty last emptied the box 3 days ago, but this morning when she arrived to work, she noticed that the box was empty. She later learned that the custodial staff had emptied the box in the regular trash because it was someone new. They didn't know. What did Betty do wrong? What are the ethical obligations at this point, and what should Betty do? Let's start with what Betty did wrong. Betty did not properly dispose of client sensitive information. Now you may think that it's internal, you're in an office, it's in a box, it's going to be shredded. It should be shredded right away. In an office, there's always people like custodians or other, visitors walking the halls that could see that information, grab it, take it, think it's to be disposed, throw it out into the regular trash, and we violated Rule 1.6. We've also improperly disposed of client documents, not reasonable manner. So Betty either needs to get the Fitbit watch and make her steps down the hallway every week or every day, not every week, every day, and shred stuff before she leaves, or there needs to be a new system. Maybe move the shred box down, but try that out. But there needs to be something more reasonable to protect, because that was what Betty did wrong. Now, what is Betty's obligation? Betty needs to immediately alert the attorney she works for, or tell the internal reporting process the law firm has. She should not hide the information. She should not keep it a secret. She should not try to fix it herself and go yell at the custodian. She needed to let the supervising attorney know immediately, so that the incident response plan of the firm has one can be activated, client communications out, assessment of what data was breached. That's what we need to know. Part of that too is Betty could sit down and make a list of the documents that she thinks to remember as being in the shred box, so we know which clients are affected. We could also try to recover. Maybe the custodians just took the trash out at 6 a.m. and the dumpster trash guy doesn't come until 6 p.m. Maybe someone can go dumpster diving and pull it back out, and we can shred it. I recommend sending Betty. She did it in the first one. But there are things that need to happen to protect the firm, and those communications need to start formulated in the incident response. So Betty needs to tell someone, follow the firm's guidance, and not try to hide it at that point. The next one, breach of confidentiality. Linda is a law partner at the law firm. One day she receives a phone call from a client boss who is very tearful and clearly upset. At the time of the call, Linda was waiting in her doctor's office in a public area. However, Linda proceeded to take the call from Bob and even put it on speakerphone to hear him better. She's in a public place with Bob, her client, on speakerphone with other third parties around. What do we have? We have a 1.6 violation. We have confidential information being spoken, third parties present. We have a problem. During the call also, Linda repeatedly out loud repeated back to Bob the facts of the case, including medical conditions, evidence, strategy, and gave legal advice. The other people in the waiting room overheard the entire conversation. We have a Rule 1.6 violation. After the call, Linda opened up her laptop, typed out notes about the call with Bob. Susie, who was one of the third parties listening to the whole conversation, was also sitting next to Linda during this and could read Linda's notes, everything she was typing on her computer over Linda's shoulder. We have another 1.6 violation. Now, not only do we have an inadvertent disclosure or disclosure of the conversation and confidential information, we also have a disclosure of what Linda is typing because someone else, the third party, is reading. So you've got to watch those public conversations in public, like down in the doctor's office, as well as where you flip open your laptop. You can see it. Are there people behind you? Are you sitting in the back of the room? Is it tilted? Is it slanted? Is it blacked out? You've got to think of those conversations because we have two 1.6 violations. We have the phone call, the third parties in the waiting room, and we have the third party reading the computer screen. Linda needed to turn, Linda needed to close it and do it later. Linda needed to move away because third party reading it also counts as a breach of Rule 1.6. So that's what Linda did wrong. What are her ethical obligations? She needs to report it. needs to report it internally so the firm can figure out the communication they want to send back to Bob. They need to figure out if there's any adverse consequences, like who will report it, or they be called to testify, if they can figure those things out and what that's going to look like. And Linda needs to make sure she does these things, reports it up, follows the guidance of the firm, and follows the ethical obligations. Vitally, vitally important for Linda to do all of those things when it comes to that. The next thing we're going to talk about in a scenario is a misdirected email. In this one, Todd is an attorney at a huge law firm. Todd was in a hurry and didn't properly look at the autofill email address that populated into the email that he was tracking to his client. Instead of going to Todd's client, the email was misdirected to the opposing counsel. How many of you have ever done that? That autofill feature, how many of you have gotten this? How many of you gotten in trouble with that? Just think about that. Think about the repercussions of it. The email contained case strategy and evidence that Todd had successfully kept out of discovery that could harm his client. So now we have a misdirected email. What did Todd do wrong? He didn't pay attention to detail. He used autofill. You can actually disable autofill on your Microsoft email, which is highly recommended to disable. Also, too, autofill on your phone is never, ever a good idea. How many of you have bigger fingers than your phone screen? Or how many of you try to type and always put the wrong thing? Those are things you need to consider because those can be inadvertent disclosures, these misdirect emails, like Todd here. He's now disclosed client confidential information to a third party. Since this is kind of an opposing counsel situation, it does trigger Rule 4.4b, the inadvertent disclosure rule. So what Todd would need to do at this point is immediately when he realizes inadvertent disclosure, he needs to notify the person he accidentally sent it to and give them instructions. He needs to notify them that he inadvertently sent it, tell them to stop reading it, tell them to send it back, or try to take those corrective actions. Now, the problem is it varies jurisdiction to jurisdiction. Some jurisdictions say that the receiver of the inadvertent disclosure has to follow the directions of the sender and stop reading it, send it back. Other jurisdictions say that they don't have to do that. The recipient doesn't have to. And that the recipient could even potentially use it in court against the sender who sent it inadvertently. Normally that requires a motion and court order, but depending on your jurisdiction, and Todd would need to go to his jurisdiction and look at Rule 4.4b to figure out what to do when this type of scenario happens. If he's here in Indiana, the notification has to happen, but there's no requirement after notice. There's no requirement that the person who received it sends it back, no requirements they have to follow Todd's order, no requirements of anything. It's all just left up to professional judgment and integrity. That's a scary thought when it comes to lawyers. It's a scary thought. Think about your opposing counsel, professional judgment and integrity. So again, Todd has done something wrong. He didn't pay attention to detail. He didn't disable autofill. He wasn't even sure. He needs to look at 4.4b particularly to figure out what he needs to do in his jurisdiction. And then two, what the obligations are of the person who received it. Okay, now the jurisdiction could be a lot, could be not. Could be a scary thought for Todd's client. In addition to that, Todd needs to figure out how to communicate what's happened back to his client because his client has the right to know and make that communication under Rule 1.3. Todd should also report internally if his law firm has an internal reporting process regarding the inadvertent. Last example before we get into incident response plans and close out this session of the seminar before your break. Dan is a lawyer at a law firm. He is traveling out of town for vacation and took his computer and cell phone with him in order to work some on vacation. Dan's devices have confidential information on them of all Dan's 350 plus clients, including protected health information. Dan inadvertently leaves his laptop in the taxi that dropped him off at the airport in his hotel. He contacts the taxi service, but several customers have been in the cab since Dan got dropped off, and Dan's laptop was nowhere to be found. The laptop had no encrypted or email password protection. What did Dan do wrong? First of all, he didn't password protect and encrypt his own devices. We need to password protect and encrypt our own devices. That's part of a reasonable data security protocol. Put password protections on it, don't let other people in it, even your kids, spouses, and others, because there's client confidential information. Client confidential information in our emails, if they're linked to those devices, maybe documents saved, maybe files saved, client confidential information. We need password protection and potentially encryption. The second thing he did wrong is he left it in the cab. He was careless. We need to make sure that we remember our belongings. What should he do now? Obviously, follow any internal law firm reporting procedure, figure out the best response plan for the law firm, and then make that communication back to the client. That is the normal protocol of what do we do when these types of scenarios happen. And these ones we've gone through the examples are the most common everyday ones that are probably going to arise at some point in your future or in a colleague's future that you work with directly or now. Because losing stuff, not password protecting, hitting the autofill when you shouldn't, misdirecting that email. Doing those different things are common careless mistakes because we are fast-paced moving lawyers. And sometimes we just need to slow down and take more precautions in different areas to make sure we don't have these breaches and make sure we're not the ones causing the breaches. Let someone else, those hacktivists, those criminals, those cyber hackers, let them do it. Let us put up the defense walls. Let us keep them out. But in all these instances, you notice when we were talking about what you do when, I mentioned follow an incident response plan. Every law firm or a recommendation that every law firm has some type of incident response plan in place when a cyber attack or something, a breach or something happens that we need to notify the client and figure out what to do. And so we need to assign responsibility, maybe have a point person when these things happen. Maybe it's the internal technology department, internal systems department. We need to have criteria that activates the plan, like, is it the autofill and misdirected email? Is it something else? We start defining those things out. We need to have internal personnel and resources devoted to incident responses, especially the bigger the law firm you are, the more you're going to have. If for some reason your whole system's been hacked, you need to have a means of alternative communication with your employees, staff, and clients outside of the network that's been hacked. So you need to have kind of like a backup network that you can utilize. You need to have external resources too, potentially forensic experts, there's actually a profession where people can come in and try to hack your system and you tell them to try to hack it so you can see where your weaknesses are and they've already been fixed. So you could use those external resources too. Flexibility and changing the plan with the times. A lot of response plans not pre-COVID are different post-COVID because of just technology and how it's communications plan externally and internally, notices, keeping records of the responses, what we're sending out to clients, what we're not, those communications, so that we meet all of our ethical obligations. Preserving any digital evidence, mitigation. Some of the key things, key planning functions to consider as well. We identify, protect, and respond to anything that comes, and then recover any data that is lost at any time. So identify, protect, detect, respond, and recover anything. These are core planning functions of that incident response plan that are good to have in that plan. Just when we go back to that example, the inadvertent disclosure, the email, misdirected email, how do we respond to it? Again, I wanted to give you a little material just on where to find that Rule 4.4b. Jurisdictions do differ on that. That's from that one example. These are just the steps for that as well. Again, this is just material for you to take with you as you restudy these materials or these incidents do come up in your daily law firm life. You have something to revert back to. This is a big one. There actually was a recent case out of New York where an inadvertent disclosure was made and the attorney that received it did not notify the sender of it, receiving this inadvertent disclosure. They waited a week. Remember I said bad news does not get better over time. They got sanctioned and fined $156,000 for their trying to weaponize the inadvertent disclosure and use it against the sender. And just how they reacted was not in compliance with Rule 4.4b. So inadvertent disclosures happen all the time. We just need to protect ourselves and know how to respond to them. So I did want to give you those last 4 or 5 steps there just so you have that for your database, and just so you have that for as you're formulating your incident response plan, as you're thinking through these different scenarios, what is going to be the best option for you and your firm. With that, we have exactly 1 minute left before your break. You're at 3:45 Eastern Standard Time. If you have any questions, you can put them in the chat now. Again, my name is Mary Sheehan. My contact information is on the screen.
And through with every various issues that arise when you run business. And so let's start with hypothetical. We have a personal injury law firm. You have the owner who's oversees the practice. He or she puts in the money for marketing to help drive business to the firm every month. And the managing partner has different associates who work with him. And one of those associates comes along one day and says, I'm leaving, I'm out of here, and I've got 5 clients who are coming with me. Don't reach out to those clients anymore. They're my clients. I'm taking them. And so let's think about this discussion in that context, although a lot of what we talk about here today will also apply for partners if you had 2 owners in that same firm and one owner came to the other with a similar discussion. So who's going with me? And we've got a list of bullet points here that I'm going to go through. And actually, before we even get to the first one, which is notice to clients, the one I put before that would be notice to the firm. So generally speaking, the ABA, they've written really 2 good opinions in this area. The first one is there on the screen in front of you. That's ABA Ethics Opinion 99-414. And then more recently, within the last 4 years, the ABA issued another opinion. That's opinion 489, issued at the end of 2019. That addresses ethical obligations for attorneys when you are leaving your firm. And the ABA has said, and this is consistent with other authorities that have addressed that before you're going to start contacting clients, you need to give notice to your firm, right? How far in advance that needs to be relative to the date of your departure is going to depend on a lot of different factors. But the general consensus is before a lawyer is going to start contacting clients and letting those clients know that lawyer is leaving the firm, that at a minimum, you need to give notice contemporaneously, if not in advance, to your law. And one of the reasons for that, and it is often ripe for controversy when notice is not given to the firm until after the lawyer starts contacting clients. My example reference, I have certain clients that are coming with us. The law generally says, especially for partners, you are going to owe fiduciary duties to your other partners or to your law firm. The law on that is going to vary state to state, but in general, it's worth looking to see, do I owe fiduciary duties to either my partners or the law firm? And that is significant because if you as a lawyer start contacting clients to leave the firm before you've given notice to your firm, there is a basis to potentially bring a claim against you for fiduciary. The same can also be extended to associates. There are several cases around the country that have found that associates of a law, even if you're not an owner, may be found to owe fiduciary duties to their employer, not necessarily to the individual owner, but to the law firm as a whole, which means you should give notice to your firm before you start contacting different clients about coming. So either you're going to give the notice beforehand or you give notice contemporaneously. But the recommendation, more so because of potential fiduciary duty violation, is to give notice to your firm before you start contacting. So then from there, of course, it's notice to the clients. And the authority generally is, we always remember, our client's interests are paramount. As lawyers, we always have to be in a position where we are looking to advance our clients' interests and putting their interests ahead of ours, which means while this may be an exciting new opportunity for the associate who is leaving to start his new firm and has some clients that's coming along with, and so feels comfortable that there will be revenue and be able to sustain and hopefully make more money, we have to be mindful that client interests are paramount, meaning there may be cases that we shouldn't take, or cases that we are not going to be competent to take. And those are things that, as lawyers, we have to be thinking of. Now, notice to clients, the ideal situation is a joint notice. Of course, that's an ideal scenario where it's an amicable parting, no hard feelings, nobody's going to be upset who's at the firm to see that you leave. And in that scenario, the authorities, ABA and other states that have addressed this, say the preference is to prepare a joint notice to the parties. And that joint notice will essentially say things like, so-and-so is leaving the firm. Here is the contact information for the new firm that he or she will be at. You as the client have an opportunity to stay with us. You have an opportunity to go with the lawyer to his or her new firm. Or in fact, you have a right to go hire somebody else. If you're not comfortable with either of us for whatever reason, you as the client have the choice to hire a new firm. The authority generally says those are the types of things that clients need to be told when a lawyer is departing a law firm. And the obligation really arises under Rule of Professional Conduct 1.4. And that sets forth our duties as lawyers to communicate with our clients, including developments that are material to their case. So whether you're in the midst of negotiating a transaction for a client or handling a lawsuit for the client, if you as the lawyer who is either primarily responsible for that matter or providing substantive continuing involvement, if you are going to be leaving the firm, that is material information that we as lawyers have a duty to bring to the client's attention. Now that obligation not only runs directly from the lawyer who is handling the client's matter to the clients, but it's also an obligation that is imposed on the managing partners of a law firm. And that really derives from Rule of Professional Conduct 5.1, which speaks to sort of the managerial or supervisory responsibilities for attorneys in law firm. So we go back to the hypothetical. If the partner in the firm is not necessarily responsible for the day-to-day handlings of certain cases that the associate says he or she is taking with, the manager of that firm is still responsible to make sure that the clients are aware that this lawyer is leaving the law firm. And so when you're talking about the ethical obligations when a lawyer is departing, we want to look at it not only from the perspective of the lawyer who's leaving, but from the perspective of management to make sure that clients are aware that a lawyer is leaving. At times, the lawyer might say, look, I'm not trying to take any cases with me, or really there's only one or two. And then the rest of it, I'll find someone else here in the office who's going to transition and take over for me. Management of the firm has an obligation to make sure that the clients are aware that there is going to be sort of an internal transition in the representation. Not surprisingly, the law generally says when a client hires a lawyer, the entire law firm now represents them. And most often, clients may say, well, so-and-so is my lawyer. But in fact, the duties run from the entire firm to that client. And as a firm, if you have one lawyer assigned to a matter, or primarily, and you know that that lawyer is leaving the firm, it is your obligation to make sure that that client is informed that there is going to be a change internally in the representation. So that, again, that client has a right to say, well, no, I don't like so-and-so, or, I really hired your firm because of that person, and if she's leaving today, then all else being equal, I'd rather go somewhere else. So notice the clients is key. one of the things to keep in mind is, and this happens on occasion, and we'll talk a little bit more, is at times law firms want to outright preclude their associates or attorneys from unilaterally notifying clients of their departure. And I would say generally courts are weary of provisions in either partnership agreements or employment contracts or written policies or procedures that outright prohibit the departing lawyer from notifying clients of the fact of his or her departure. The ABA does say you can't agree in advance that the notice is going to come from the firm, right? So that is okay if an agreement is reached in advance with the lawyer about how are we going to handle notice to clients if you are going to depart them. And so in that scenario, if the attorney knows that the management has taken on that responsibility and that's been agreed to, and as the lawyer, you know that that obligation is going to be satisfied, that the clients are going to be promptly notified of it. But if a policy doesn't exist, or there's nothing in the partnership agreement or employment contract that speaks to what to do in the event that one lawyer is departing the firm, you cannot outright ban a lawyer from notifying a client of his or her departure. And then the next question becomes, well, who will you notify, right? Some firms can be smaller and may only have a very finite group of clients, and you work on other cases, and other firms are massive with a lot of lawyers, and you may only work on a very small number of cases that that firm has and not even be aware of the dozens, if not hundreds, of other clients that your firm represents. The notice in that situation needs to be limited to those cases that the lawyer has an active role, right? You're either primarily responsible for the case, or you're someone who is having substantive conversations with the client, someone who, if you were to ask the client who at that firm do they turn to, they would consider you as that attorney. It doesn't extend to every file in the firm, right? So if you have a law firm, let's say a personal injury firm with 5 different attorneys, and each attorney is assigned his or her own cases, and there doesn't tend to be overlap. Then if attorney A is leaving, there's not an obligation to notify clients for attorney B through E of attorney A's departure. If those clients aren't working with that attorney, they're not typically interfacing with that attorney, and don't perceive that attorney as someone who's primarily responsible for their case. Now, related to that, the authorities out there say lawyers who are departing a firm shouldn't go try to grab client lists that the firm may save or keep, and then try to solicit everybody on that client list, right? So that derives from Rule of Professional Conduct 7.3, which is generally the same in every state, and that talks about soliciting persons when the lawyer is looking to be hired by them. Permissible if it's somebody who you have a prior family or professional relationship with. So, you might have brought your cousin to the firm, you're not working on it. If you're leaving, yeah, the rule says you have a right to go ahead and reach out to the cousin. But short of that, if the firm has a number of clients who you have never worked on their cases before, then the exception about solicitation of clients doesn't apply because you've never worked on those accounts. So there is authority out there that says, and then you can tie this back to breach of fiduciary duties, that if lawyers try to take client files with them or lists and contact everyone at the firm to let them know that they've left and you're trying to solicit them to join your firm, you can easily run afoul of any fiduciary duties that you may go to, as well as violate Rule of Professional Conduct 7. Now, I always analogize it, once notice has been given to the firm and notice has gone out to the clients. For anybody who's seen that Jerry Maguire film from many years ago, at that point there tends to be sort of this race to get clients either to stay or to go with the new firm. And those kinds of discussions are going to occur, right? Especially if the client clients reach out and want more information. Clients may reach out to the managing partners of the firm. They are concerned that their matters will continue uninterrupted. Or they may reach out to the departing lawyer, have questions about, can you take my case with you? You're going to have the bandwidth and the staff to have my case if you don't have all the resources that you currently have at this firm at your new firm. Those kind of discussions are going to take place, and in some sense, what's fair is fair, and having those discussions with clients. However, the authorities do say you can't defame or disparage your current firm if you are the departing lawyer, and you're trying to incentivize these clients to come with you. So it's sort of all about the tone. You are able to say, I'm happy to continue the representation. I have the resources, the institutional knowledge. I would love to continue to help you out through my new firm. But you can't sit there and try to entice them to terminate their attorney-client relationship with their assistant. Making fraudulent statements about the firm, misrepresenting their continuing capabilities, interests, financial ability to represent the client. Those kinds of communications are improper, frowned on not only from an ethics standpoint, but again, you can tie it back to it may be perceived as a breach of fiduciary duty. Now, often that can be very much he said, she said, and can be difficult to prove both from the employer's perspective as well as from the departing lawyer's perspective. It's key to think about then, if you can't agree on a joint notice with your current firm in terms of what is going to be communicated to the client about your departure, to be mindful of the type of language that you include in that notice. The ABA opinion that I mentioned, again, they distinguish between a lawyer having a right to notify his or her clients that there's an ability to continue to represent them, versus incentivizing or trying to convince a client to terminate their current attorney-client relationship. In some sense, it seems like 6 in one hand, half a dozen in the other, but as lawyers, that distinction does have meaning. Okay, so then we talked about whether we can solicit clients that we've worked with and the types of communications that we have. Another question that typically arises is, well, now that I've left the firm, what about reaching out to the employees that had a great assistant who worked with me? I had a great paralegal that I worked with. I'd really like to bring them along to my firms. Am I allowed to reach out to them? And then as the employer, are you allowed to outright ban that attorney from communicating or attempting to solicit your current employees, their former co-employees? So generally, this tends to be more driven by contracts, whether there's any employment agreement between the attorney and the law firm, partnership agreements. Often I will ask when this issue arises, if there is such a contract, is there a non-solicitation provision within that contract? Because generally speaking, courts will enforce those if they are reasonable in scope, duration, and we feel that those appropriate consideration given for that non-solicitation. But beyond that, you have a balance between a right to fair competition, and all else being equal, we are not going to outright prohibit competitors from reaching out to your employees and saying, hey, I'll pay you more money to do the exact same thing. I've got greater benefits, I've got more flexibility. And so courts, in the absence of a provision that outright prohibits solicitation of former employees, courts frown on claims that try to shut that down, merely because that could be perceived as harmful. Instead, this really comes up, and again, the law can vary on this state to state, within the guise of a tortious interference claim. And the claim will have more or less merit depending on whether the person you are soliciting himself or herself has a contract with the law firm or is just an at-will employee. So if it's somebody that has a contract and you are trying to incentivize that employee to breach their contract, right, to terminate it early, there may be a greater risk of exposing you, who is now outside the firm, to a tortious interference with existing contractual relations claim. Or if that person is an at-will employee, then courts will generally look to say, did you take some improper action while trying to solicit that employee? Again, for example, disparaging the law firm, making false representations about their qualifications, accusing them of crimes or other improprieties. Courts look to see if there's something to hook the conduct on, as opposed to purely reaching out and saying, hey, the grass is greener over here. I'd love to sit down and have lunch with you to see if you're willing to cross over. Next topic here related to this as well, how do we deal with fees for cases that either stay with the firm or leave and go over to the new firm? And this gets litigated a lot, more so with partners who leave law firms and they take long-standing clients with them. Clients that the firm perceived as continuing sources of business, revenue for the firm, helped keep other attorneys within that firm busy, and now no longer going to be available to them. It also comes up in the contingency context. Go back to my hypothetical. Perhaps you have a firm who has spent a lot on marketing and advertising and other resources to help draw business into the firm. Those clients don't necessarily look at any one lawyer in the firm as their attorney so much as they were driven to that firm because of the catchy advertisements that they saw on TV or listened to. And those firms have some interest in being paid a percentage of the fee that may arise out of that case if there's a favorable settlement or judgment. If nothing else, because they initially took on the risk, advanced the costs, and they are the ones bearing the expense of all the marketing to help drive business to the firm in the initial instance. So that is often something that is ripe for controversy. There's a lot of authority out there that refer to, call them financial disincentive clauses that may appear in employment contracts or partnership agreements that try to address beforehand how money may be divided up on cases that tend to leave with the law. And a lot of that drives from the Rule of Professional Conduct 5.6, which speaks to attempts to restrict a lawyer's right to practice law. And it stems from the idea that the client's interests are paramount, and the clients have the absolute right to choose what lawyer will represent them. At least here in Nevada, and I believe the authority is the same in other states, a client cannot be accused of breaching his or her contract with a lawyer simply by choosing to terminate the relationship and hire a new lawyer. That in and of itself, the simple act of a client saying, you know what, I decided I'm going to go elsewhere. I appreciate all you've done for me, but I'd like to end our relationship. In Nevada, and I know it's true in other states, that in and of itself will not support a claim for breach of contract, because courts don't want to infringe or limit a client's ability at any point to choose to go elsewhere. And so Rule 5.6 is sort of the corollary to that and says, well, then as lawyers, we can't enter into agreements that prohibit us outright from continuing to represent clients, from taking clients with us if we choose to go to a new platform, or preventing lawyers from taking clients with us. So over the years, then what we've seen develop from this is to then have agreements that say, well, look, we're not telling you that you can't take clients with us, but for any case that you take with you, let's say it's in the contingency context, we will get 80% of the fee that derives from any future settlements or recoveries you may obtain in that case. Doesn't matter the stage of the litigation the case is at, doesn't matter if just came in yesterday, or we've had the case for 4 years, we're gonna get 80% of the fee that derives from that case, even if it settles years, if not months from now. Or similarly, if you've got billable clients, but there's some provision that speaks to either a continuing obligation to share in a percentage of those fees, or as a result, the lawyer's interest in the firm and whatever payout he or she may do is going to be reduced by some percentage to account for the fact that that's to be generating revenue from those cases that we're going to. So I would say that the majority of cases that look at this issue generally frown on and refuse to enforce those provisions in contracts because they're seen as indirect restrictions on a lawyer's right to practice. For example, again, in that contingency context, that lawyer might say, God, I want to take these cases with me, but I can't support that if I'm going to have to give 80% of the fee to this prior firm, even if I've got to do all the work. Or I'm not going to take these billable clients cases because I don't want to risk having my payout be lessened for what they otherwise owe me if I take this on. So I would say that the majority of cases that have taken up this issue have said we're not going to enforce those types of provisions because they're seen as void as against public policy by indirectly doing what Rule 5.6 says lawyers can't do directly. To help draw your attention, if you're interested in what some of those cases are, so as I mentioned earlier on, the ABA Opinion 489, which was released in December of 2019, toward the end of that opinion, it cites a number of cases where courts have taken up these issues and have said, no, we are not going to enforce those types of provisions. Now, I will also say there are some cases that do support that. California, for example, if we have any California lawyers logged in with us here today, California courts have not outright prohibited those types of provisions. I will also say that Arizona has likewise said that there may be competing business interests on behalf of the firm that may justify whether those types of provisions are enforceable or not. And then there is, in Philadelphia, there is an ethics opinion that was released that says we got to look at the facts and circumstances of that individual provision to decide if it's something that's going to be enforceable, because it is more so protecting the interests of the law firm, legitimate business interests, and less so, if at all, simply attempting to disincentivize the departing lawyer from taking a case further. So based on my research, California and Arizona seem to be supportive of those types of provisions, but there are also a number of competing cases around the country. For example, New York that have said, in Illinois, that say we are not going to enforce those types of provisions because they are doing what Rule 5.6 says you should know. So certainly if this is something that you are either considering doing, you're about to make a move, and you're not sure whether you're going to be subject to that type of provision in a contract that you may have, or if you're the employer and you know that you have somebody leaving and you have that type of provision in your contract, whether you believe that will be enforceable or not. I know in my practice, I've had this come up a few times in the personal injury context where I've given advice about provisions like this to include in employment contracts between the firm and associates that are working at that firm. And what I've usually said and how we tend to work it out is it shouldn't be just one percentage irrespective of the stage of the litigation, who sourced the client, things like that. So for example, you may have a provision that says we are going to share fees based on a certain percentage if the case settles prior to litigation or arbitration, right? That percentage may also vary if the lawyer who is leaving also happened to originate that client or had been assigned to that case because that client hired the firm as a result of the firm's marketing efforts or the work on behalf of the managing attorney. Percentages may also vary depending on if litigation has been filed, what stage is the case. Is it pleading stage? Is discovery underway? Are we starting trial next week? So it can certainly get more complicated, right? And there's a lot of different variables and stages that you can work into that sort of analysis. And you can see then how that can get complicated and the percentages can vary. But in those situations, you as the employer, if you're in the position of wanting to enforce that provision against the lawyer, it is easier to argue that it is a reasonable provision, that it is intended to fairly compensate the firm for the time and effort that was already put into the case, the risks that were undertaken initially when the case was brought in, and the fact that the firm as a whole puts out costs and expenses without any guarantee that they are going to recover. And so I've worked on those provisions before, and if you structure them that way, then in the future, if the departing lawyer attempts to void those provisions as being unenforceable as 5.6 violations, you as the employer are in a better position to say, no, we took into account case may be at different stages and that this lawyer may have gotten a greater percentage because it's a client that they sourced as opposed to somebody that the firm assigned to him or her to him. So those are things to be thinking about once you know that you have a lawyer leaving, and how are we going to be dealing with attorney's fees that we as a firm have lost, or that the lawyer at the new firm may now be seeing more of than he or she was going to deal with. Next thing to think about is as you're getting ready to leave, and this is something that, especially as you're getting ready to leave for the parting with, is conflicts, right? So if you're starting your own firm, it's probably going to be less of an issue than if you are joining another firm. And it is important as the lawyer to be checking for conflicts if you are going to be joining a new firm, to make sure that if you're going to represent to certain clients, that you are able to continue their representation, and you're not going to immediately run into a conflict and be unable to handle that. So under Rule of Professional Conduct 1.6, generally in most states, although all information related to representation of clients is confidential, there is often an exception about revealing information related to prior clients that the lawyer has represented for purposes of checking conflicts, right? So as a lawyer, if you are leaving a firm or planning to, you may want to look to get a list of clients that you have represented over the years and have that available to help clear conflicts before you jump ship, so to speak, and plan to go over to a new law. I have seen it before where lawyers sort of jump the proverbial gun on that, and they give notice to their firm and they plan to go join a new law firm. And then it turns out the law firm that they are looking to join represents a very big client who's got a number of cases adverse to the lawyer's former firm. And a screen isn't possible because the lawyer has been active, and the firm withdraws that employment offer. And now that lawyer is between a rock and a hard spot because they've already given notice of their departure, but the new firm can't hire them. Now they're scrambling to find a job because before they checked and cleared conflicts, they gave notice to their firm that they were leaving and going somewhere else. So getting a hold of the list of clients that you've represented in the past to help make sure that you can clear conflicts at your new law firm. It said it's something that may not be an issue if you're hanging up your own proverbial shingle, because if you've been representing those clients, then odds are there shouldn't be a conflict and you're able to continue with that representation. Related to that, there may be instances where you're going to be screened at your new case, right? You may have had some connection with something at your old firm, or there may be a basis under the rule to say, well, somebody else at your old firm was working on this matter, and so there's The law imputes knowledge to you about that case. And in some states, Nevada, there are instances where a screen may be imposed so that your new firm will not immediately be conflicted out of continuing to represent that client just because they have hired you, right? I always tell clients to be very wary of hiring lawyers from firms that you are actively opposed to because of issues that may arise. You may be welcoming a motion to disqualify. Even if a screen is allowed and you take all the right steps to screen that lawyer right out the gate, there's still a risk that you are going to see a motion to disqualify. Screens, the sufficiency of those, can vary depending on the size of your firm. I can say, for example, at our firm here, the types of measures that we intend to impose when we put a screen in place is we will write up a memo and we will distribute it internally that says so-and-so is being screened from this matter. That means they are not going to have access to any of those files. No one is to discuss that matter while so-and-so is around them. And if you ever have emails to distribute or documents to distribute from that case, you'll make sure that that attorney does not receive or be given access to copies of those documents. We typically have everybody acknowledge that they've received that memorandum and they understand it, so that they understand the limitations. We will then use our IT people that do what they do to go into our system to physically and electronically lock the attorney out of access to that particular file. So we have what we call our M drive, where all of our active cases are by client, and our IT people can essentially prevent one or more persons in our firm from being able to access those clients' files on our M drive, so that those persons, the screens are remain in place and they don't suddenly have access to information that they shouldn't have access to. Next point here, and it's kind of related to this, is job negotiations. So you're in the midst of working at a firm, you're representing a client, and you got a lot of respect and admiration for the lawyers on the other side, and you say, boy, I'd love to just go work for them. I don't know how I feel about the lawyers that I'm working with here. I'd love to go work with you guys instead. That can be tricky, not only from a fiduciary duty standpoint, because depending on what happens in that case, or if you don't get hired, if there's reason to suspect that you're not trying as hard or working on your place, and your firm finds out that you were approaching the other side about employment opportunities, you may not be long for that firm, and the client, if there's an adverse result for the client, may turn around and blame you for it. So, when that has happened, most often we say, look, sit tight, let's have that kind of discussion, if at all, at the conclusion of the representation, but certainly not while the case is actively pending. Something sort of related to that, and this also ties back to Rule of Professional Conduct 5.6, and I've seen this come up and have had to deal with this in the past, is lawyers who are representing clients cannot, in the midst of those negotiations, say to the other side, look, I'll convince my client to settle this case if, as soon as we get done, you guys hire me, or your client hires me to now be there, right? Because in that instance, there's concern that you as the lawyer are looking out for your interests ahead of your client's interest, right? Or, as crazy as this may sound, I've seen this as well, negotiating where you say, look, as soon as we get this case resolved, you're going to pay me $100,000 non-refundable retainer, and then I'll start giving you advice about how to handle this case. Needless to say, if your client learns about that, they're going to say, well, wait a minute, that $100,000 should have been coming my way. How do I know that they wouldn't have paid that to me if you hadn't conditioned it as a payment that should be flowing to you as part of this settlement? So be very wary about trying to negotiate to be hired by the opposing party or the opposing party's client as a function of attempting to resolve a case for your client. Okay, so at this point, we have a lawyer who's given notice to their firm, we've given notice to the client. Let's also talk about the files, and we're a little out of order here on bullet points, but in terms of the files, the question arises, well, what are you gonna take as the lawyer? And then as the employer, you might say, can I just lock them out and refuse to give them everything? So of course, the answer is always somewhere in the middle. You always start with the idea that your own work product, right? Files that are personal to you, motions that you've drafted, letters that you've written, contracts that you have created and you have developed. Lawyers most often have a right to keep copies of those. Next, if you have files for clients that have said, you know what, I've decided to go ahead and transition the representation. I'd like to leave with John or Sarah and join their new firm. Then as the lawyer, you have a right to have that file transitioned over to your new firm, right? Things that you don't have a right to though as a lawyer, and in another instance where lawyers tend to get in trouble, or where at least it creates controversy and gives rise to disputes, is when lawyers just mass download everything in their firm. Right? They go and they download templates and forms and documents on cases that they never touched, on matters that they never handled, but they say, oh gosh, if I'm going to be starting on my own, I'd love to have all. Or as part of going to this new firm, you said, hey, look, we've got such great work product. I am going to grab all that work product. We are going to be miles ahead of everybody else, and we'll now be able to compete with my current employer because they've spent years, time and attention and money developing all of those things. The answer is no, don't do that as a lawyer. Don't try to mass download, mass print, all of that sort of documentation, on the eve of getting ready to depart, or even once you've given notice to them. Nowadays, especially, IT has capabilities to go back and to see, who accessed which file on which drive and who printed off documents. You'd be surprised nowadays with the right technology. You can see every file that somebody has accessed, including if they've accessed files that they had never accessed for the last 10 years, and now suddenly they're in there downloading, printing copies of it. So be wary, as great as that might sound at first blush. Feel like you're going to be a step ahead of the game by getting copies of documents that you've never worked on. Generally speaking, the courts frown on lawyers who do that. Relatedly too, and this is if this is in place, employment contracts or partnership agreements may speak to what types of files you will or will not be allowed to keep, and what documents you may have to return once you have departed the firm, right? And that always presents, an interesting issue, especially with lawyers who, text or communicate with clients on cell phones, iPads, other mobile devices. What do you do as both the lawyer and as the firm once you leave that law firm? So let's take the iPad, for example. I myself nowadays like to go to court. I'll download all of the documents on my iPad. I may have my hearing notes, arguments on my iPad that I've got typed up, discussions with the client, things like that. If I were to leave 5 years from now and I got all those notes on my iPad, what do I do? Do I keep those notes? Do I have to destroy them? Do I need to delete them? And so as the lawyer, generally speaking, the rules of professional conduct impose a time that you need to retain copies of files following the conclusion of the representation, right? So you as the lawyer, and here in Nevada, it's 5 years, may vary in different states, but there's a certain time period in which you need to retain copies of files, right? As law firms, even if the client left, that is still a duty that will be owed to that client for while that client was there. And so if you know that the departing lawyer may have certain documents that are important material to the matter, on a laptop, electronic device, and it's not also saved, I see it locally or within the system here at the firm, then you need to take steps as the managing attorney to make sure that you obtain copies of those documents so that you have them in your file and that you can satisfy your ongoing retention obligations as the firm that may be owed to you, who is now your client. Generally speaking, in terms of what the file looks like, right? There's generally two schools of thought. The most obvious one is everything, right? All emails, all documents, drafts, legal research, public filings, final copies of executed documents, sort of like the virtually everything you can think of is considered a copy of the file. And then there's another school of thought that speaks to sort of the final work product, right? Which means final letters, final copies of sale, purchase and sale documents, final copies of pleadings, but not necessarily drafts and legal research. So depending on the state that you're in, it is worth looking to see what the courts there consider to be the client file, so that you have some sense of what sort of documents you need to retain, as well as what sort of documents you may need to turn over as a firm to the departing lawyer who has said, hey, these clients have elected to transition their representation. One thing to not do in terms of files as the managing partners is to lock somebody out before they've left the firm, right? So some comes and says, hey, given my 2-week notice, it's been great, but I'm going to try to go do this on my own. I'll be out of here in the next 2 weeks. Because that lawyer is still going to be working on cases at that firm, the law firm shouldn't lock that lawyer out, preclude them from being able to access the files for the clients, preclude them from looking at calendaring entries in case there's hearings that may be coming up next week. Tying back to the idea that we want to always be protecting client interests. And so if you give a notice on a Monday, and it turns out you're closing a sale on Wednesday, we don't want to put that lawyer in a position where he or she is locked out and unable to go to closing, and somebody won't be capable of getting up to speed in time to take over for them. Or if there's a hearing in a couple of days, and similarly, we don't have someone who can go handle that hearing. As a law firm, it may be hard feelings. We may not be thrilled to know that so-and-so is leaving, but it may not be the right word. We don't want to be vindictive about it and put the clients at risk simply because we're concerned that the lawyer may start mass downloading documentation, mass downloading documents. Once the lawyer has left, it is generally appropriate for the firm to ask for, sort of an accounting of what the lawyer has. If, for example, there was a company issued cell phone, certain documents that the lawyer might have that are originals, that the client matters that the lawyer is not taking with him or her, it's appropriate for the firm to sort of ask for an accounting from that lawyer so that they can make sure you get a hold of any documents that you're going to need to keep as a firm, originals for wills, promissory notes, things along those lines. If for whatever reason the lawyer was holding on to those documents, then we as a firm, if we are keeping those cases, then we need to make sure that we request and obtain all that sort of documentation and other material. Let's say, for example, the client has a retainer on trust with the law firm, right? If the client is leaving, then we need to make sure steps are taken to actively transition those funds, perhaps less any final fees that may be owed to the firm, so that that property then moves over to the new lawyer's trust account and is retained. So thinking about an accounting so that we keep track, both for the departing lawyer and the managing attorneys, of any property that needs to be overseen and handled. The last thing I know I've run a little bit over on this topic. There's always a lot we can talk about when it comes to lawyer departures. But the transition. So if you've given the notice, when you say, hey, I'm gonna be here for a couple more weeks, the real professional responsibility and then case law say that you're gonna help transition in the representation. So you're going to typically look to create memos to give status updates, right? I've got, so many hearings coming up in the next few weeks. I've got these cases stacked trial in a few months. We have these clients who are lined up for signings in the next 2 months. Anything you as the lawyer were in charge of or had primary responsibility for, it is appropriate to take steps to make sure that if the case is going to stay at the firm, you assist in transitioning the representation. I can't say it enough, but we always, again, want to be looking out for our clients' interest. And sometimes it's a good opportunity to sit down and reflect on all the work we've got, balls that we may be juggling in the air, and ensure that both you and the firm can look at sort of holistically and say, what's going on, and make sure everything is taken care of. And sometimes that's an opportunity to look at it as the departing lawyer, and you might say, I'm not capable of taking literally everything that I'm working with me to my new firm, right? On the one hand, especially younger lawyers who say, look, I'm never here to turn away work because I'm trying to generate work, right? I want to become that rainmaker. But on the other hand, from a competence and diligence perspective, we as lawyers have to make sure that cases we take on, we're competent and able to handle. And if we look and say, gosh, I end up relying on a lot of resources here at the firm to handle this kind of workload, I'm not going to be able to handle this workload if I'm out on my own until I get up and running. I have other employees that I hire, or maybe another attorney to help me. Because as a lawyer, if we take stuff on that we can't, then we expose ourselves to potential malpractice claims or disciplinary issues for not being able to meet client expectations. So making sure you help transition the representation, and then you take a step back to make sure that any case that we're taking, we're able to handle. And for those that are staying with the firm, management then has the ability to take steps to ensure that someone takes over, right? But we're assigning cases to somebody else within the firm who will be handling them. We've got another attorney who's going to take over these transactions. And then if we're at a scenario where we lost the only lawyer in our firm who can do this kind of work, then we are going to go look to hire someone new, or we're going to have to co-counsel with someone to make sure that we can actually continue representing. So a lot of different ethics issues to think of if you're out of here, if you know somebody is out of here. The final point I will place on this is, it's a good idea if you don't have employment contracts with all your attorneys, which often law firms don't, and partnership agreements, maybe more often, but not always, spell out what is a divorce going to look like, right? We're more excited about partnering up and less so about what it'll look like when we break. So if you don't have employment contracts or provisions like this in partnership agreements or operating agreements, it's good to have written policies and procedures that are distributed within the firm to your attorneys, so that everybody sort of knows the ground rules, right? We know what the field looks like, what's fair game, what's not fair game, so that if you get into a scenario where everybody's rushing to steal clients and they're taking documents, and somebody's going to feel burned, it's going to get acrimonious, and all else being equal, we're often adversarial enough for our own clients. We try to avoid being adversarial with our own attorneys. With that, I'll check to see if there's any questions if anyone has about lawyer departures. Seeing none, I'm going to go ahead and switch over to the second topic that we had for today. We got about, 20 minutes left for those of you that I know are watching the time, but make sure that we get all of our ethics credit in for today. And that is, I'm in over my head, and realistically, there's so many ways we can look at that, and we could come up with a lot of different scenarios and hypotheticals about when our lawyer's in over their head. And really, what that means is we're about ready to get into trouble. Or we can see that trouble is on the horizon. How to work. One of the things that we do a lot of here at our firm is representing attorneys in disciplinary matters for the state. And so, the clients may start out in the disciplinary proceeding, and then if we're successful in dismissing it or limiting whatever discipline is, then on a going forward basis, you look back and say, how do we avoid those types of problems, and what can we do to try to prevent future victims? So one thing that comes up a lot that our firm talks a lot about in CLEs, we call them the 4 letters that really lawyers should always be thinking about, always have in their pocket, have them as templates in their firm, because they can help really define when a relationship starts, when it ends, what you're doing, things along those lines. So those 4 letters, we call them engagement letter, disengagement letter, declination letter, and then I'm not your lawyer. So I'm gonna briefly talk about each one of those letters. First one, obvious engagement. Under Rule of Professional Conduct 1.5b, generally speaking, lawyers do not have to have written engagement letters for matters that are handled on an hourly basis. We're representing the client billing by the hour. While it is prudent to have the fee arrangement reduced to writing, you don't have to. The only requirement for written fee agreements is in the contingency setting. Rule 1.5c, which every state has adopted the same rule, is that if we are representing a client on a contingency basis, then we are going to set for the fee in writing, as well as certain things related to calculation. For example, is it going to be a percentage of the gross recovery? Are we going to subtract costs before or after we calculate the contingency fee? Things along those lines. But the engagement letter is valuable for a number of different reasons. Surprisingly, it happens a lot. But in the corporate context, you have a lawyer who's been doing a lot of work for a company. They're often doing work for some of the officers, owners of that company. And very quickly, lines are blurred, right? And you're not necessarily sure who you're representing. Do you represent everyone, right? And what have you been hired to do? So, well, it seems obvious, but one of the real ways to help avoid trouble is to say exactly who your client is and spell that out in writing, right? Which also, the inverse means we are making clear that the company knows who I don't represent. Or the owners or officers of this company know that I only represent the company's interests, right? Identifying our client makes sure we're not in a scenario where we start representing everybody, and oftentimes interests after a while may diverge, right? So take, for example, a startup. 2 people come together and they say, hey, we want to get this business going. We really want you to help us get it off the ground. We say, I'm glad to help. You get the LLC formed. Then they start entering into contracts with vendors. You're now negotiating contracts with vendors. And then you're discussing personal issues that come up with these 2 individuals. Maybe somebody has a claim brought against the company for harassment, and you're defending both the company, but the owner is looking to you. So, very quickly the lines can become blurred, and someone can say, well, you're both the lawyer for me and the company. But that may no longer be appropriate. It may give rise to a conflict. So an engagement letter can spell out precisely who you represent, and then also who you don't. The scope of engagement is also appropriate, right? Just because we are hired to represent a client doesn't mean we are now giving advice to that client on anything and everything that comes before them, right? Often what can happen is client says, well, no, I look to you as my lawyer. You didn't warn me about this particular issue. So identifying and crafting precisely the scope of your representation ensures that in the future, you as the lawyer are not accused of failing to give certain advice to your client on a matter that, by all accounts, is outside the scope of your representation. I will tell you that there's a limited exception to that in a few states. California being one of them, that often. Look to California for guidance on stuff, and our Supreme Court hasn't addressed the issue. And that is, as a lawyer, if something comes to your attention, even if it's outside the scope of your representation, you still have a duty to bring it to your client's attention and advise them to go get it. Right? You know, an example might be is you are in the midst of negotiating settlement that might have pretty significant tax consequences. Right? And you as a lawyer might say, look, I'm not a tax lawyer. I have the foggiest idea how we treat this for tax purposes. Is this going to have any significance from a tax perspective? If you as a lawyer see that there may be a tax issue there, even if you've not been retained to represent the client in tax matters, the law suggests, and it's unsettled, depends on what state it is, you need to at least bring that to your client's attention and encourage them to go get separate counsel to speak to you about it. Right? Other things an engagement letter can do is set forth what the client's obligation. So as odd as this may sound, generally speaking, your duty of communication is a one-way street. Right? We as lawyers have a duty to reasonably communicate updates about cases to clients, consult with clients about objectives, generally talk about what our strategy is, and then ultimately procure decisions on whether to settle, initiate litigation, right? Subject to the law saying clients can't defraud lawyers, you know, the restatement of the law governing lawyers says, look, client doesn't owe you a duty to communicate with you about things, so long as they're not misleading. An engagement letter can now affirmatively create that obligation, right? To say, hey, you're going to keep me updated on, you know, change of phone number. You'll be available for depositions. You will provide whatever documents I may need to handle this case. That can be significant, let's say, in class actions. If you are representing potential class reps, and you as a lawyer want to make sure that this individual knows their obligations and is going to be cooperative and provide the necessary support that's needed to pursue the case, right? So an engagement letter can make sure you spell out what the client obligations are, including communicating with you. Other things that can speak to are remedies in the event of a dispute with us. Okay? The ABA has said that lawyers can include provisions in engagement letters about privately arbitrating disputes that may arise related to the representation, right? So, you know, all else being equal, at times it's beneficial to not have a public airing of a malpractice claim against the lawyer. And so, as long as the appropriate disclosures are given to it, lawyers can include provisions in engagement letters asking clients to agree to arbitration.
That was
of
the
any
guy
disputes that
from
arise.
the building you're
You
going to
need that
say?
in writing, of course, you need the.
Line
30 is fine,
sign off
thank
on that. You know, ABA says, kind of explain to them what that means. You're giving up what might be block discovery rights. You won't have the right to jury trial. There may be different appeal rights. from
Oh,
the
shoot.
Decision that's entered by the arbitrator. But so long as those types of disclosures are made, an engagement letter is a good opportunity to adjust what might be a normal form of recourse that a client would pursue if you and the client decide this. So moving on, just in the interest of time, disengagement letters. So these are important for a couple of reasons. So, you know, sometimes a case will come to its natural conclusion, you've settled it, or you just finished the transaction that you were hired for. And it's sort of understood, that's it, you know, it's great, appreciated getting to know you. You know, here's hoping you create more work that comes from this relationship in the future. But you know, there's not more active work that we're going to be doing. The disengagement letter makes it very clear when that representation ends, and now turns that client into a former client for conflict of interest, right? So if we know now you are a former client, the rules about taking on conflicting representations are a bit narrow, right? When you're dealing with concurrent conflicts of interest under Rule 1.7 of the model rules, it's a little broader than Rule 1.9 when you're dealing with former client conflicts. So making someone a former client might now allow you to take on new work that you weren't able to take on while that former client was current. The other thing it does is it ensures that that client doesn't show up in 6 months and say, hey, where are we on this? Or, has anything changed? Do I need to be worried about changing legislation? I just saw the tax code got amended. How does that implicate me? And so a disengagement letter should say, look, we are not going to continue to be giving you legal advice. You won't continue to look to us for legal advice. And so there's sort of a cutoff point so that if something happens, 6 months from now, 2 years from now, the client doesn't say, hey, you're still my lawyer. So I look to you and tell me what happened here and how does that end. The declination letter under Rule of Professional Conduct 1.18 that generally speaks to duties owed to prospective clients, right? You might get that phone call and have a lengthy discussion with someone, and then either you don't take the representation or the client didn't hire you because maybe they were trying to put you out, or you're too expensive, or they found someone that they like a little better. The declination letter makes clear that you've not been hired to handle something for a prospective, right? So that's important because let's say it was a very minimal conversation, surface level at best, got the names, you ran the conflict check, you spit out your qualifications and what you charge, and you never heard from the client again. But then the other side shows up and wants to hire you. A declination letter can help avoid the adverse party saying, hey, you've got a conflict because I consulted with you in confidence, I shared a lot of information. Or no, actually I was planning to hire you.
I'm looking at legal research in Arizona.
The rules of professional conduct, again, they can vary, but
There's
here in
a
Nevada,
5-year
for example,
statute of limitations.
you can limit what information prospective client reveals to you. You can sort of warn them during that initial conversation. Listen, I'm not your lawyer. Please don't give me any confidential information.
Well,
just give me the basics.
I started there around 2000.
Let's just talk about it. It's something I'm not sure handle. I'm interested in handling your hire me. And you can put sort of the disclaimers on the conversation, and then that way you may not be prohibited from representing somebody else in relation to that matter. The declination letter puts that in writing, right? It confirms that you made those disclaimers, you gave those disclosures during your conversation with the client, so that if you do end up on the other side or representing someone else in the same matter, you don't have a client moving to disqualify. The last letter there, the I'm not your lawyer letter. There are times where you've spoken to a witness or somebody has reached out to you and you're worried that in the long run, they're going to say, oh yeah, that's my lawyer, right? Or in that corporate context, you as perhaps in-house counsel are interviewing employees of the company, maybe even former employees, and there's reason to believe that those individuals might say, well, yeah, you're the company lawyer, right? You're my lawyer too. And so those individuals, if you have reason to think as the lawyer that they perceive you as their lawyer, then the onus is on you to address that misunderstanding, right? There's a lot of authority out there about sort of implied attorney-client relationships, and when unknowingly can a relationship arise between a lawyer and a third party. There has to generally be something more than the alleged client saying, oh no, I intended to hire that person and I gave him a bunch of legal advice. You need something more than that. And you look for instances like, did the lawyer offer or agree to help that individual? Did they make an appearance, send a letter, anything along those lines? And then the corollary, of course, being, is there a letter from that lawyer to that person saying, I'm not your lawyer, right? So I'm squaring up any misunderstanding. I am not your lawyer. So those are good letters. I've shortchanged them. I could spend a lot more time discussing some of the nuances, but as a law firm, we always encourage people to have those letters. They go out when it starts, and then they go out at the end, and it helps keep track of what you're doing, who you're representing, and who you no longer. Next topic here, and I will also run quick on this one, doing business with clients, right? And this is something, at least the most of the authority out there will tell you, don't do business with clients. It is ripe for problems. In Nevada, at least, they are presumptively fraudulent. It just has terrible connotation to it, right? If you're starting out essentially as the underdog with two arms tied behind your back. And so the idea that presumptively that it's an improper transaction means you've got an uphill battle as a lawyer to justify, right? So this all stems from what's Model Rule of Professional Conduct 1.8A, again, adopted in virtually every state in one form or another, that speaks to all the different things you as a lawyer have to do if you are nonetheless going to go forward and do business with clients, right? Now, we're not talking about, you represent Walmart when you're going over there on Saturday to buy Halloween decorations or Christmas decorations. We're talking about, you've been doing a lot of business deals for a client, and the client comes along and says, hey, I got another investment here. You want to go into this together, right? You know this stuff, and hey, you've seen there's pretty good returns here. Why don't we create an investment vehicle and we can combine our resources and really make a killing. Doing business with clients, if you look at the rule, there's a lot of steps you have to follow. The terms of the transaction have to be fair and reasonable to the client, which means if a third party were to look at this objectively, would it appear that you as the lawyer were taking advantage of the client or striking a deal that a non-party who didn't look to you as their lawyer wouldn't strike with you? You need to make sure that you tell them, consult with other counsel and give them a reasonable opportunity to do it, which is not 15 minutes before you're going to sign. You need to spell out the essential terms of the transaction in a separate writing. So again, let's say you've got an investment vehicle that you're forming, and you say, well, our ownership interests and our contributions, they're all going to be laid out in the operating agreement for the LLC that we're forming. No, you got to create a separate writing that really in plain and simple terms spells out what the material terms of the transaction are, and the client is signing off to an acknowledgement. Finally, are you representing the client as a part of that transaction? Then if you are, then you've got conflict issues that trigger from that. You could be going from bad idea to worse idea if not only you're doing business with the client, but the client is looking to you for legal advice in connection with that same transaction. So, you can't, the law doesn't say you can't do it, but be careful. And the final thing I will note on that is the authority out there generally says that clients can try to unwind those transactions if a lawyer doesn't follow Rule 1.8A to the T. And even if it turned out to be a decent deal, right? And even if you're like, hey, come on, you still turned a profit on this. There's plenty of authority out there that says you can effectively disgorge whatever the lawyer earned in that transaction if you show that they didn't do everything at 1.8A profits. Last minute here, and then I will wrap this up. Fee splitting, I'll jump right to that, in terms of getting in over your head. And that's, referral fees. The law changes in different states. Some allow pure referral fees. I mean, client hires you, but you can't handle it. And so, but you know someone who can, and you refer it over to somebody. You're not going to do any work, but you say, I'm going to get 25% of the recovery. Some states permit that. Other states require that you take on some responsibility. Either the fee is proportional to the work you're going to put into it relative to the work that the other attorney is going to put into it, or you just agree to be jointly responsible for it, right? Which means you're going to be liable for anything that goes south on it. So you want to look to what the rule is in your state. The model rule requires one of those two options. The Nevada law allows pure referral fees. The other one is, well, hey, my friend, he's not a lawyer, but he referred this case over to me, and I go ahead and cut him 25% of the fee, that I earned from the case as a thank you. The answer to that is no. we look to rule professional conduct 5.4. That generally speaks to sharing fees with non-lawyers, right? And with very limited exceptions that don't apply to that scenario. We can't cut people in on cases, whether it's a percentage or even just a flat. You can say, well, I'll give $100 to every client you send my way. The rule of thumb. So, people may approach you and say, hey, $100 a client, I can find you some good work. While that might sound intriguing at first glance, you're running into some deep, scary waters if you choose to. I see I've run through my time today, so I appreciate everyone's attention. Again, if there's any questions, please throw them into the chat. Otherwise, again, my name is Josh Gilmore. I'm an attorney at Bailey Kennedy in Las Vegas. If you ever would love to talk ethics or would like to reach out to me further on any of this, please feel free to do so. With that, Dave, I will turn it back over to you.